All persons having business before the Honorable Chief Judge and Associate Judges now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
All right, good morning. Welcome to the District of Columbia Court of Appeals for our virtual arguments, which are being live streamed for public access. We have three cases set before us this morning, the first of which is Joseph Barber v. United States and Willie Glover v. United States. Are counsel ready to proceed?
We are ready, Your Honor.
Okay. Is there a plan, counsel, for any division of your time?
Yes, Your Honor. Stephen Kirsch, good morning. On behalf of Willie Glover, I believe each counsel for the appellants will take 10 minutes in opening and reserve 3 minutes for rebuttal. Okay,
are we missing a party on behalf of the government? That's where I was. I may not have, I don't see anyone from the U.S. Attorney's Office with us.
Wait a minute, Chief Judge. Yes, I'm gonna bring them in now.
Okay, thank you.
Go. Okay, you're welcome. All right.
Good morning, Mr. Ham. Can you hear us? Good morning.
Yeah, sorry. I think Mr. Brannon kicked me out for a second, so
yeah,
I'll be back though.
We're short a party here. Thank you. I just called the first case, Joseph Barber and Willie Glover, consolidated cases versus the United States, and I was asking for appellants how they intended to divide their time.
And Your Honor, for Mr. Ham's benefit, it will be 10 minutes each counsel in opening, and we'll each reserve 3 minutes for rebuttal.
Okay, I think that sort of equals more than the 15 minutes that we usually allot, but in this instance, since it's a consolidated case, we're fine with that.
Your Honor, Sean Day for Joseph Barber. There has been an order that gave 25 minutes total, and Mr. Brandon said that he couldn't split it in half minutes, so instead of 25, he was giving us 26.
That's fine. All right, Mr. Kirsch, are you ready to proceed?
I am, thank you. And again, Stephen Kirsch on behalf of appellant Willie Glover. I'd like to start with the Winfield third-party perpetrator issue. And I note that since Winfield was decided by this court, I believe 1996, it's always been deemed to be a theory of inclusion, not exclusion. And in support of that, I cite to the government, a case the government cited, Bruce versus United States, where this court very clearly and very specifically outlined Winfield and talked about it as a issue of inclusion. And the court also came out and said that close questions should be decided in favor of admission of third-party perpetrator defenses. Now, when we go back to the facts of this case, what we have is that we have a homicide of a man who's killed with a knife. And obviously that's a very significant issue in this case. Joseph Connor, who was the person that the defense sought to introduce evidence about him related to a third-party perpetrator, was on the scene of the crime. The police taped off the crime as they typically do. And this man, Mr. Connor, within an hour was on the scene with a knife. And the apartment where the killing occurred, also of great significance because this goes to opportunity, was an open air drug market. You had people coming and going constantly in and out of the apartment for the purposes of purchasing or selling narcotics. And as this court has said repeatedly, that the proffered Winfield evidence need only tend to indicate a reasonable possibility of a third party. And so that's the legal standard, and that's been the legal standard for a great number of years. I also want to emphasize that when this issue was initially raised, Judge Isco ruled that the Winfield, the third-party perpetrator, test evidence was admissible. So his initial reading was that this should come in.
Can you remind us, Mr. Kirsch, why he, procedurally what was going on that led to him revoking that initial ruling?
The government then filed a motion in limine, I believe, and that's when, and Judge Isco said he wanted to go back and reconsider it after taking a look at the case law. And that's what he did. He went back and then he changed his view. And Judge Isco found that he said that the evidence about Mr. Connor was too, quote unquote, remote and speculative, which is a standard in the law. So Judge Isco was not going outside the standard. He was following the standard. We submit it was clear error for him to rely on that standard.
What would you say to the point, Mr. Kirsch, which goes to the question of opportunity? What would you say to the point about the evidence that Mr. Manning, I guess, monitored the apartment and controlled access to it, and there being no evidence that he gave access to Mr. Connor? And then there was testimony, I guess, by other witnesses about who was in the apartment, and no one testified that Mr. Connor was there. What's your response to that?
Well, my response is that Mr. Manning was an unreliable witness. And again, I understand that even if a witness has issues, such as Mr. Manning may have had, they can still testify. But it goes to the, I would submit, Your Honor, it goes to the overall environment in that apartment, because virtually every witness who testified was using drugs. It was a chaotic scene in the apartment. And so the issue with Mr. Manning is that, is this someone that you believe or don't believe? But that would be a jury question. The same with the rest of the witnesses, but the jury should have been allowed to hear the evidence of this Mr. Connor being at the location with a knife. And also, very importantly, he wasn't just at the location with a knife, he was crossing the police lines, and the testimony is that he was crossing the police lines on multiple occasions, such as they had to go arrest him.
Can I guess, follow up a little more on that? Can you talk a little more about how this alleged third-party perpetrator defense would have changed the outcome for your client in particular, Mr. Barber?
Yes, thank you, Your Honor. My client's Mr. Glover.
I'm sorry, Mr. Glover. I apologize.
Well, number one, the record is what the record is, and Mr. Glover's trial counsel put Mr. Glover on the scene, and he stated that, and so that's a factual issue that we have to live with. But this goes to the state of mind of Mr. Glover, and this goes to what was his intent when he was entering the apartment. Because what we do know from the record is that Mr. Glover had no contact whatsoever with the decedent. He didn't know him. He never interacted with him. He had no animus with Mr. Wills. And so where it would come in would have been that even with a trial lawyer saying, well, Mr. Glover's on the scene, it still doesn't make him responsible for the felony murder. It could have been this Mr. Connor. And again, the government in the foot.
Don't we have to have a little more than it could have been? Mr. Connor, it could have been Mr. We have to show a little bit more. Otherwise, to get to this Winfield third-party perpetrator. And that's I guess I'm asking you to hone in for us on what that more is here, other than somebody else was there.
Well, the little more is that this man, Mr. Connor, was armed with a knife, and he's right outside a building where within that building is an apartment that's nothing short of an open air drug market, and people are buying and selling drugs. And we know historically that when you have drugs and they're being bought and they're being sold in an apartment, there's a high propensity for there to be violence because it's uncontrolled and things can get out of control, and things do get out of control very quickly. And so The question that could have been put to the jury is, why is this man, Mr. Connor, trying to cross police lines? What's going on with him? Why is he trying to get in beyond where the police have cordoned off the area? And why does he have a knife? And we know the killing was done with a knife. And we go back to what Detective Weber testified to, and he said he would have been interested in another knife holder. This is the government's primary witness saying that. And what he said was, it's entirely possible that another knife was involved in this homicide. And so all of those factual issues put into context, I would submit respectfully to the court, shows that there is clearly a reasonable possibility. We're not out on a rope just speculating and making things up. These are hard and fast facts that the record supports.
What case from our court, Mr. Kearse, comes closest, is your best authority on this Winfield issue?
Your Honor, I would cite Johnson versus United States, which is what we principally relied upon in our brief. And Johnson was a reversal on a Winfield issue. And I would submit to the court that this case, Mr. Glover's case, has far stronger reasons for allowing the Winfield evidence than did Johnson. And just briefly, in Johnson, there was clearly animosity between the decedent and the defendant, Mr. Johnson. With respect to this case, there is no animosity between Mr. Glover and the decedent. There's no evidence that they knew each other. Absolutely none. And also with respect to Mr. Johnson, there was evidence that he called his mother from the jail and said, "It's taken care of." And the government argued that it was the homicide. And I also submit, maybe most importantly, is that in Johnson, there was a jailhouse informant who said that Mr. Johnson had confessed to him. There's nothing close to that in this case. So the evidence in Johnson, again, which resulted in a reversal, was far stronger than the evidence that we have in this case. And one other factor is that in Johnson, what this court found to be very important is that the third-party perpetrator had access to a firearm, and that was emphasized in the opinion. And in this case, we have that also, because when the proffer wasn't just that Mr. Connor was just some person rambling around out there. This man was armed with a knife, and it was a knife that was used to kill Mr. Wills. And so for those reasons, we would submit it clearly should have been information that Judge Isco went with his first inclination, was to admit that. All of these issues related to the competency of the witnesses, the reliability of the witnesses, all that goes into the mix, and the jury could decide whether or not they believed them or didn't believe them. But we would submit that the jury should have been permitted to hear the testimony about Mr. Connor and make up its own mind. And again, the question is not whether or not Mr. Connor was the actual perpetrator. The question is, does it create a reasonable doubt that Mr. Glover was or was not the perpetrator? And again, within the factual confines of the case, we would submit it clearly would have served Mr. Glover's very best interests to have had the jury had the benefit of a full record, and that without a full record, without the full plate of available evidence, we would submit Mr. Glover did not get a fair trial because the jury did not hear all of the potential evidence against him.
Remind me, Mr. Kirsch, I was trying to recall the context of that testimony by the detective that you mentioned when he said that it was entirely possible that another knife was involved. Was his answer suggesting a second knife or a different knife? Or a different knife from one in the kitchen of the apartment? What was the context of his answer?
Well, it wasn't clear from the record, but Judge Isco did allow the defense to cross-examine to some degree, not to the fullest degree, but allow them to cross-examine to some degree what was characterized as sloppy police work. Why didn't the detective look for this? Why didn't the detective check for blood? Why didn't the detective follow up on the knife? So to answer Your Honor's question, I don't know if there is an answer about that context other than what I've just represented, that was the focus of the cross-examination. That's why Judge Isco allowed it, so that at least you could drop the argument in on the jury that there was a second knife, but obviously they couldn't take it to the full extent and say, maybe that was the third party perpetrator. So they
And also remind me, I think that there were two witnesses, Manning and Hill, who testified about seeing the stabbing, or who knows, remembering having been told about the stabbing, but two witnesses to the stabbing. Is
Right.
that right?
That's correct, Your Honor.
And did either of them identify the stabber?
I don't believe so. And Lloyd Hill is the subject of another issue raised on behalf of Mr. Cray. We all joined in on that, but
Right.
he was I would submit to the court, an absolutely unreliable witness, as was Manning, because again, they were using illicit substances, and they just were the kind of people that you'd have to really thoroughly cross-examine, and everything they said.
Right. I think we appreciate your argument on that point. And my question was really just more to what was said, whether either of them purported to know who the stabber was.
No.
Who was the witness who said, based on build and some other things, that he thought he knew who they were?
Well, that was Rhonda Gregory. And she was the subject of the argument regarding her proclamation that she feared for her life. And she made an identification of a tall, skinny person. And then in closing argument, the government said, well, the tall, skinny person is Mr. Glover. So she didn't necessarily name him by name. She identified him by height and build. But the government took the extra step and said, that's Willie Glover.
And who was the witness who testified about what Mr. McRae said at the bus stop? Who was that?
I don't recall the name of that witness. And again, that was after the fact. Mr. Glover was not at that bus stop. He had gone to the hospital, but Mr. McRae did make an admission to that person and said something to the effect, well, he got what was coming to him, or he got what he deserved, something like that. But off the top of my head, I don't recall the name of that witness.
Right.
And so,
All right. Mr. Kirsch, I know you reserved a few minutes for rebuttal. Is there anything you wanted to close out your argument with?
no, thank you. If I did want to address the recusal issue, but if I'm out of time, I'm out of time.
No, go ahead and address that.
Okay, thank you. This issue that came up, Judge Isco was clearly very concerned about the issue related to his intern. It was Judge Isco who brought it up. The government did not bring it up did not even address it until Judge Isco brought it to everyone's attention. And it clearly was an issue I would submit to the court that needed further evaluation. It needed an evidentiary hearing. And Judge Isco said on 3 or 4 occasions that he needed a hearing. He needed the issue to be briefed. He needed case citations in support of the argument for recusal. He suggested a hearing with citations, and he's very specifically said, we have to have a hearing. And what do we know about this issue with the intern? The intern worked as a summer intern within the Office of the United States Attorney. The intern worked on this case with the lead prosecutor, and she was assigned a task related to this case. She was assigned a task of shepherdizing a motion in limine, I believe. But it went further than that. The intern and the assistant U.S. attorney who led the prosecution in this case had some type of relationship outside the court. And we know that because the assistant United States attorney explained to the court that they went to an alumni function at George Washington University because they were both alumni at George Washington University Law School, and that apparently a letter of reference was written on behalf of the intern. Now, I'm familiar with the case law regarding recusal and regarding with the issue of an appearance of impropriety, but my point is that, and Mr. Glover very strongly objected to Judge Ishko not recusing himself. He was the only defendant who specifically asks for a recusal. So he preserved his record. And my issue before this court is that we do not have a complete record because a hearing was not conducted where it could have been further explored on what exactly the relationship was between the intern, the assistant United States attorney, and all the other information that could have come to light in a hearing. So my position on the recusal is that we're requesting a remand for the trial court to conduct the hearing, conduct the inquiry, and then we'll have a complete record to bring before this court. But as the record stands now, it's not complete. And so we would ask for a remand on that issue. And thank you for the extra time.
Thank you, Mr. Kirsch. Mr. Day?
Yes, thank you. I'd like to start with Detective Weber's sweeping testimony from out-of-court statements. There were only two witnesses, Edward Manning and Lloyd Hill, who incriminated the
Mr.
appellant.
Day, I'm sorry to interrupt you, but just for the clarity of the record, if you could state your name and your client that you're representing.
My name is John Day, and I represent Joseph Barber.
Okay, thank you.
Mr. Manning had consumed 2 bags of crack cocaine, 1 to 2 bags of heroin, and alcohol as well. He identified a masked robber as Joseph Barber based upon the conversations, which he didn't elaborate upon. A common body type, Detective Weber said Mr. Barber was 5'7", 160 pounds, plus type of clothing, also without elaboration. He testified before the grand jury that he did not witness the stabbing. And then he testified at trial that he did, and he said that both versions were true. So he was impeached, not a terribly reliable witness. Mr. Hill wasn't any better. He was on cocaine, he was on heroin, PCP, and alcohol. He testified he recognized Mr. Barber based upon also clothing, without elaboration, and a limp that Mr. Barber was not established to have, and no one else mentioned. He admitted that his memory failed frequently. He could not say for certain what testimony was from memory, from imagination, or from gossip. And so what the government did is they brought in Detective Weber. Detective Weber laid out the entire case. Every single part of the government's narrative was put in through Detective Weber. He recounted information from unidentified sources and from interviews with Manning and from Hill. He even bolstered those statements. He testified that the MPD was able to identify Mr. Barber as one of the perpetrators. He said that evidence that Mr. Barber was one of the perpetrators included speaking with witnesses about what happened that night. And he testified that Mr. Manning remembered the incident very clearly.
Mr. Day,
Yes.
can you, I'm sorry for interrupting, but while you're recounting these things, the government says that a lot of this was not introduced for its truth. I'm not sure if I have a question here, but that's something I'm interested in along the way as you're discussing Detective Weber's testimony. It's kind of confusing about what, was it ultimately used for its truth, even though it wasn't admitted for that? That's an issue I'm interested in while you're discussing it.
Some of it was, and some of it wasn't. And it was certainly going to be confusing for a jury. This is a month-long trial trying to figure this out at the end, what came in for what purpose. The prior consistent statements, that is the Detective Weber testifying about what Manning told him and about what Hill told him, That came in as substantive evidence for the truth of the matter asserted. The evidence about the unidentified sources, that came in as police procedure. That came in to rebut the suggestion that the police investigation was somewhat sloppy. And really the only argument there for the defense was that John Connor was there afterwards near the police tape, and he had a knife, and they did not look into him. And that was the argument, that the police investigation was sloppy. And based upon that, Detective Weber was able to come in and lay out the entire case. And at the end, it's very hard for the jury to figure out what's coming in for what purpose. And the government concedes that as to the prior consistent statements, the trial judge got it wrong. Judge Isco concluded that it did not matter whether or not the motive to lie existed at the time of the prior statement. In Mr. Manning's case, it was the desire for parole. He was incarcerated, and at the end of his interview with Detective Manning said, "Hey, is there something that you can do about my parole?" And based upon that, the government came in and said, "Okay, let's talk about the entire interview." And they admit that Judge Isco was wrong about the timing of the motive to lie was irrelevant. It was clearly relevant. The government argued that the motive to lie did not exist until Mr. Manning raised it at the end of the interview. Now, he was on parole the entire time of the interview. He was aware of his parole the entire time of the interview. And it wasn't until the end that he said, "Hey, can you help me with the parole?" And that's an
But
incredible.
just to clarify, this is still the government's argument, right? Okay, I was a little confused by your point that they conceded an error, but you just mean conceded that a narrow thing that Judge Isco said was wrong.
Right. And the government's position was an incredible one, that the motive to lie basically does not exist until it's said out loud, that during the entire interview, it did not exist. It did not exist until Mr. Manning raised it at the end of the interview. Clearly, the motive to lie existed during the entire interview. Therefore, the prior statement of Mr. Manning was not free of the bias. It had the same bias as his trial testimony, trying to get favorable treatment regarding his parole. Therefore, should not have come in at all.
What about our case law saying something along the lines of prior consistent statements are not really that useful?
I believe, yeah, right. So the prior and consistent statements are self-serving, and it has to be very focused. The prior consistent statement has to come in. It can't come in willy-nilly. It has to come in very focused and directed to the impeachment. And this was not directed to the impeachment. The impeachment was, "You're looking for favorable parole treatment, are you not?" And so then they brought in the prior statement, which was colored by the same bias, the same desire for favorable parole treatment. So yeah, this was not focused. It was not narrowly focused on the impeachment. It was everything that he said came in. Everything that Mr. Hill said came in through Detective Weber, a much better conduit. He wasn't on drugs. He was able to testify even that Mr. Manning remembered everything clearly. So it just allowed them to present everything through Detective Weber. They also argued, the government, that
whose testimony do you argue that Detective Weber's testimony bolstered? You said it allowed them to have everything come in, but you also seem to be arguing that he was essentially bolstering, even rehabilitating some of the witnesses that weren't as reliable. Could you be more specific?
Right, he did that in at least 3 statements. 2 statements were related to the MPD having found the perpetrators, assuring the jury, yes, indeed, we did an investigation, we found the perpetrators. The other statement was that Mr. Manning, again, who was on 3 different drugs at the time, that Mr. Manning remembered the incident clearly, something that Mr. Manning didn't testify to. So yes, he was able to bolster their testimony in that way.
Was there, I'm trying to recall, was there an objection at trial?
There were many
to this-
objections.
this-
There were many objections cited in my brief and in the reply brief as well. Many objections during his testimony about Mr. Manning and about the police investigation, that this was going way beyond allowing him to testify to everything. And there were even statements by the defense, look, this is how you should do it if you're going to try to do it to get around this hearsay. Okay, based upon that conversation with so-and-so, what did you do next? Not allowing the detective to testify about whatever everyone told him. And the court cautioned the government not to do that, not to get carried away, but the government did get carried away. There was a point in time when there was a transition from what Manning said to what Hill said. And it was a very seamless transition, and there was no new objection as, hey, now you're getting into Mr. Hill. But there had already been many discussions about prior consistent statements and what could come in. The trial judge said it was all coming in. Everyone at the time understood why Mr. Hill's statements were coming in through Detective Weber, and that was as a prior consistent statement. And that was even part of the jury instruction, specifically naming Mr. Hill as somebody who made prior consistent statements. Now, eventually the judge decided to give generic instructions without naming the witnesses, but everyone understood what was going on and why the evidence was coming in. But even if not, it would be plain error. It's in addition to the other errors regarding the police investigation and regarding Mr. Manning, allowing all that evidence in. Now, if I may, I'd like to just briefly mention the sufficiency and with a focus on the stabbing specifically, even assuming that Mr. Barber was there. He was in the room, he was stabbed, we know that. But his argument was he was caught up in the melee. But even if that's not the case, we have Mr. McRae, who had a specific beef with both Mr. Wills and his girlfriend, Ms. Harrison. And he'd been arguing with Ms. Harrison earlier in the day, left, came back with the two masked robbers. The masked robbers engaged Mr. Wills, and Mr. McRae went back and talked to and argued with Ms. Harrison. And Mr. Hill testified that at this time, Mr. Wills was cooperating with the two masked robbers. Meanwhile, there's an argument going on with Ms. Harrison and Mr. McRae. Mr. McRae slaps Ms. Harrison to the ground. And at that point, Mr. Wills started swinging a knife, and Mr. McRae picked up a knife from the kitchen and stabbed and killed Mr. Wills. And then later on, he went to the bus stop and said, I had nothing to do with you people. It had to do with Mr. Wills, and I punished his, I believe he said, I punished his ass, something like that. That was specific to his desire. His malice towards Ms. Harrison and Mr. Wills had nothing to do with any robbery. And so there was insufficient evidence that Mr. Barber and Mr. Glover, either of them had anything to do with the murder. It wasn't in furtherance of any robbery. It was a specific beef between Mr. McRae and the other two.
Mr. Day, and if you haven't finished what you wanted to say about sufficiency, feel free to do that. But I did want to ask you to address what I think in your brief is the second issue about the jurors who appeared to be sleeping. One thing I'm curious about is what does the record establish about what parts of the trial were, missed by? I know in particular, I'm interested in the juror who seemed to have been sleeping through part of Mr. Hill's testimony, which of course it was one of the government's key witnesses. Can you tell timing wise where the problem was occurring in the trial?
It was established in the record that one of the jurors, I forget which one, 5 or 14, was sleeping during Mr. Hill's cross-examination and during parts of that, including the impeachment. It's hard to say how long, and it may be hard for the juror to say how long. As I mentioned in the brief, if there's a count from 1 to 100 and you fall asleep, you might know, okay, I missed from 22 to 53. But when you fall asleep during a trial, during testimony, you don't exactly know what you've missed. There were 2 jurors who were sleeping during substantial parts of the trial. The defense moved to have them both replaced. And unfortunately, the trial court asked questions that essentially you could only answer one way, that set it up. Hey, I know a lot of times we are listening with our eyes closed and we're paying attention with our eyes closed. Is that what you were doing? Something along those lines. And they said, of course, that is what I was doing. Even though it was clear that the jurors were sleeping. Later on, there was some more sleeping, and Mr. Barber's counsel specifically said, look, it's pointless to ask these questions in this way because these questions are designed, they're only going to elicit affirmative responses. They're going to elicit responses that they know will please the court. So yes, there's a record that they were sleeping. There's a record that there was an objection. There's a record that the defense was not happy with the way that the jurors were being questioned because they were being questioned in a way that could only elicit one response.
Mr. Day, how, maybe this is a hyper technical question, but the time periods for which the particular jurors were observed sleeping, was that correlated to, how closely was that correlated to particular testimony that they could have missed if they actually were sleeping? And then what's the harm or the key parts of the testimony that you think
Call from Washington, D.C.
could have impacted your client negatively here?
Right. What I can say off of my memory is definitely parts of the cross-examination of Mr. Hill. Ms. Barnes briefed that one the closest, and we adopted her arguments. Unfortunately, her client died. But I know in her brief, she went through very specifically exactly the parts that she identified the jurors as missing. But I know I highlighted a few in my brief, and I know that one was during the cross-examination of Mr. Hill, who was just one of 2 witnesses who ID'd my client.
And at the end, I'm sorry, the jury was polled at the end, particularly the jurors that appeared to have been sleeping.
Right. Well, they were asked these questions about, did you miss much? Were you at times? I saw your eyes were closed. Were you listening with your eyes closed? Because I know I do that sometimes, is what the judge said. And they said, oh yeah, that's what I was mostly doing. There was one juror who said, I think this was July 5th. One of the jurors said, yeah, it was a bad day. On July 5th, I was tired and I was sleeping. And I would refer to Ms. Barnes's brief and what I highlighted in my brief as far as what parts were missed.
Your reference to her brief reminds me that I wanted to ask you and also meant to ask Mr. Kirsch, and perhaps he can address it on rebuttal. Both of you and both of your clients adopted the arguments in Mr. McCrae's brief to the extent they were applicable to them. And I noted that a number of the points made were also argued in either Mr. Glover's brief or Mr. Barber's. But there is a severance issue in Mr. McCrae's brief. And my initial take upon reading that was that it was not relevant to your clients, but I wanted to ask you whether you agree with that assessment.
I believe I agree with your entire characterization. I did look through her brief prior to oral argument. I believe either I or Mr. Kirsch covered those areas. Other than the fact, I think Ms. Barnes specifically went through exactly when the sleeping jurors were sleeping as best as she could.
Right.
And I believe only one defendant did a motion to sever. Mr. Barber did not, so that argument would not apply to me.
All right, and Mr. Kirsch, I'll be interested in your response to that on rebuttal as well. I'm sorry, I forgot to ask you earlier. Thank you, Mr. Day.
Mr. Day, I guess I know that you've reserved some time for rebuttal. So if there
Oh,
are
yes,
no
thank you.
questions at this time, or nothing further from you at this time, we'll hear from the government and the appellee, Mr. Hahn.
Thank you.
Thank you.
Thank you, Your Honor, and may it please the court, Brian Hahn for appellee of the United States. I guess I'll start with the Winfield issue that appellant started with. And the trial court here did not abuse its discretion in not allowing the Winfield defense. I note that it's not clear what evidence appellants wanted in that they weren't allowed to get in. I think there's sort of a small sliver of daylight here where they weren't allowed to argue that John Connor was the one who did the killing or was involved in the stabbing, but they were allowed to argue that the police did not investigate him as a potential suspect enough to eliminate him as one of the people who had been involved. And so I don't think that they've identified any evidence that was presented, that they would have presented that wasn't already presented at trial. As the court knows, the prosecution, put on the police officer who arrested Connor, introduced his body-worn camera video of the arrest, introduced the knife that he was later found with at the station. They missed it on the first go around when they first arrested him. And so I don't think there's a lot of evidence that appellants want. There's no evidence that appellants want admitted, even after I think it's appellant Glover's attorney speaks to John Connor and still does not make any representations to the court as to what they want to be admitted. So I think that in terms of this is sort of two sides of the same coin, that there isn't a lot tying John Connor to this attempted robbery and then murder. And it's two sides of the same coin because on the one hand, that's part of the test for whether or not the Winfield defense is admissible at all. And then on the other side, it is a question of even if the court erred in not allowing appellants to argue that erred in not allowing them to argue that John Connor committed the crime. It was certainly harmless because all the information about John Connor that would have pointed to him as a suspect in the case was already placed before the jury, and they clearly rejected it. If there are no further questions about the Winfield issue, I'll just go in order, I guess. The second issue that Mr. Kirsch raised was the recusal issue. And I think that just to correct a couple factual things, the June 11th transcript at 11, the prosecutor was a reference for the internship. And then I think she said she was invited to a alumni function. I don't think she says she went to an alumni function. But either way, when Judge Isco learns from his clerks that the judicial intern has been walled off from the case ever since the beginning of the judicial internship, the judge decided then that no recusal was necessary. And I think that his sort of initial reaction to it, not knowing all the facts, is exactly why the standard for judicial recusal is, if there would be if there's a conflict that arises in the mind of someone who knows all the relevant information. And once Judge Isco was aware of the relevant information, he's probably put these screening procedures in place a long time ago and maybe didn't remember what they were. But once he figured out that the judicial intern came in, made a list of the cases that the intern worked on, and then the clerks walled off the intern from the beginning of the intern's internship, then I think no recusal was necessary. And of course, the government cited a couple of cases where there were law clerks who either have, one law clerk's husband. This is I think the case in Mathis, circuit case in Mathis.
Mr. Hahn, I didn't mean to interject, but when you say from the beginning of the internship, I think counsel for Mr. Barber argued that they did do some work. I believe it was, I think he said shepherdizing a case or doing some research.
Oh,
So what, can you talk about what the intern specifically did and why that did not, in the government's view, require recusal?
yeah. So the intern, when the intern is working at the U.S. Attorney's Office, the intern worked on the case and shepherdized a motion from, I don't remember what appellant, if it was all appellants or just a couple of them, but shepherdized a motion for the U.S. Attorney's Office. Once the intern started the judicial internship, the intern reported that she had worked on this motion as part of the internship for the U.S. Attorney's Office, and then was walled off in the judge's chambers from the case. And so the intern did no work for the judge on the case and didn't talk to the clerks or the judge about the case at all. So, I think I apologize if I didn't specify that the intern did no work on the judicial on this case during her judicial internship. But
Mr. Hahn, I think Mr. Kirsch used the word concerned. He said that Judge Isco was very concerned about this issue. Is that your assessment of the record?
so I think the Judge Isco has some concerns at the very beginning when he first learns about it. And I think that's why he goes back and talks to his clerks about it. And that's why he raises the issue with the parties. And I think, properly so, the judges, I think ethically the judge should have raised it with the parties because we want to be very careful about these ethical issues. But once he learned all of the relevant facts related to it, I don't think he was concerned at all about the issue.
Can I also go backwards for a moment, back to the points you made on the third-party perpetrator issue, the Winfield issue? You said that defense counsel was able to get in evidence about Mr. Connor, and all that counsel was precluded from doing was arguing the issue. And I'm wondering whether you're suggesting that the jury heard enough about this Mr. Connor that jurors themselves might have treated his presence going through the police tape as reason to doubt the involvement of the defendants in the stabbings. Is that what you're suggesting, that jurors could have put this together for themselves?
Yeah,
I'm trying to sort of assess your comment that all that they were kept from doing was to argue the point. Is it that the point would have been clear to jurors anyway? Is that what you're suggesting?
I think that's right, Your Honor, because the appellants were allowed to argue there is a person with a knife on the scene later in the night, and that the police didn't investigate. They didn't look at this person closely. They didn't do anything about this knife that the person had. Detective Weber was told about it, but he didn't do anything about it. Detective Weber says during his testimony that looking into another knife would have been important. And so they basically point the finger at John Connor without saying that they're pointing the finger at John Connor. By indirectly doing so, saying that the police did not investigate this suspect who was there at the time. And I think the jury would have understood that as, not just a simple, the police didn't have their acts together, but also that this person, at least as appellants were claiming, was someone who had been involved.
Mr. Hahn, can I ask you, I'm sorry, I was going to ask you about Detective Weber's testimony.
Yes, Your Honor, we can move on to that issue.
Yeah.
Did you have a specific question or that you wanted me to answer first, or?
Well, I wanted, if you could address some of the concerns raised by counsel for Mr. Barber, that Detective Weber's testimony essentially, despite objections, was allowed to go too far and essentially bolstering and rehabilitating some of the other government witnesses that had some significant issues.
Yeah, so I want to just split Detective Weber's testimony because there's a couple of areas of testimony that he goes through. Detective Weber first goes through the background of the investigation. So he testifies about things and this is where the judge instructs the jury they're not allowed to use this as truth, anything that the detective learned for its truth, only to describe the background of the investigation. And the things that he testifies about in this portion of the testimony, and he later testifies about prior consistent statements from Manning, from Lloyd Hill, and some other witnesses. So we're putting that aside for now. But this particular testimony is in direct response to allegations that appellants levy against, in particular, Detective Weber from the beginning of the case. So this is it's the June 19th transcript, and it's at 58 and 62, where one counsel in opening statement says, "This is Detective Weber's web of lies." And he describes how Detective Weber is basically just trying to pin the murders on appellants in this case, and about how he influenced and massaged witnesses in secret witness meetings in order to get them to testify the way that Detective Weber wanted them to. So Detective Weber testifies about the steps that he took during the investigation to rebut this bold claim by appellants that he's basically framing them. So he testifies about how quickly it took to get warrants for appellants Barber and Glover based on the information that he received. He testifies about interviews that happened at the scene and at the homicide office. And importantly, he doesn't go into detail about what is said in these interviews. He just says that we interviewed them and describes how they were done, the context of the interview, whether or not they're recorded, that sort of thing. And then he testifies about people in the apartment that he identified and spoke to, and then other people that he tried to identify that people said were on the scene, but was failed to find. And so the judge instructs the jury twice on this, on that the information about this area of testimony. I think the question and answers that Mr. Day was talking about in specific here was the one about how the police identified the perpetrators or identified the suspects in this crime, and that the detective said, yes, we identified them as Barber and Glover. As Judge Isco said, observed, I don't think it's a surprise to the jury that the lead detective on the case thinks that the MPD has identified the suspects that are now on trial in front of them. But again, the judge instructed the jury twice that it's not for the truth. And the second time, in fact, interrupted Detective Weber's testimony and said, this is an example of what I'm talking about when I say that this isn't admitted for its truth. It's just admitted for the context of the investigation. And then moving on, so then we'll move on to the prior consistent statements from Manning. And I think that initially, of course, many of the statements that Manning gives, that Detective Weber testifies about Manning saying are the identifications of appellants, and that's admissible. And so, I think that Mr. Day talked a lot about how the identification from Manning is the most important, evidence, and is the most important evidence against his client in this case. I think that's it is important evidence, but I think that's admissible anyway under a statement of prior identification. And I think that even if let's assume that the prior consistent statements were admitted improperly, I think that a lot of what Detective Weber testifies about is still admissible because Manning needs to be, he's able to testify about the prior identifications of Manning and also about the context, enough context that you can identify who is doing what in sort of this three co-defendant case.
Can I ask you, are you now, is this a different argument from your argument that basically the, Manning's motive to lie did not occur until the possibility of a parole letter came up in the interview? Does this argument affect, you were just saying, identification and other things that sort of fall outside the scope or were admitted under other other evidentiary rules, but the sort of, I found that argument very interesting as you, I think Mr. Day made a point of it, but it's, I guess the argument is it's very narrow definition of when the motive to lie arose. And the government's brief does concede that, well, of course, he had a very generalized motion to lie or curry favor with the government even before that. And I'm interested in it's very nuanced and very thinly sliced, I guess, the difference between those two things. They seem, under one way of looking at them, barely distinguishable. But is this a thing where, is there case law, saying two different motives to lie that are that close, actually can lead to a different result on the admission of these prior consistent statements?
So I think you said a lot there. So
oh yeah, sorry.
I'm
trying to make sense of it through talking about it, which I only confused it more.
No, that's fine. I think just initially, I do want to say that the argument that I just made, in no way impacts that argument. They sort of act in parallel, and it's even if they're inadmissible. And I think, in Blunt, this court said it's the subjective belief of the witness that creates the bias. So even if, the witness believes that something can be done, but nothing can be done, there's still bias that's created there that you can ask about. And in Mason, this court said that if there's a recent and different reason to fabricate, then that allows a prior consistent statement to come in. And so the possibility of this parole letter is only brought up at the end of the interview. And this is the June 21st transcript at 408. Manning testifies that he doesn't think that the prosecutors or the DC detectives or the police can help him with his parole. So he just sort of takes a shot in the dark there. And so I think that, I don't think there's a case that specifically is the same situation as this one, but I think that there is, in fact, a new and different reason to fabricate once the possibility of help from these particular bodies comes up.
What was that? What was going on in Mason? What were the two different motives there, if you recall?
Yeah, in Mason, the two different motives were, I think I'm now confusing it with the cases that Mason cites. So there are cases that Mason cites that talk about sort of like many different reasons to lie. And I can't off the top of my head tell you what the ones in Mason were.
That's fine. I'm sorry. I can easily look them up.
No, that's I should know that. But
one of your opposing counsel emphasized or made a reference to the detective's testimony that Mr. Manning remembered the incident clearly at the time, or at least that's what I wrote in my note to myself. Did he give testimony to that effect, and was that admissible? Can a prior consistent statement be admitted for the purpose of sort of rehabilitating a witness who has said, I'm not sure whether I saw this or heard it, or that I remember it clearly? Can you put on a witness to say, well, he told me this on a previous date and he remembered it clearly at the time?
Yeah, I think that in this court's case in Worthy, I believe it's their prior consistent statements can be brought in to directly rehabilitate the witness against specific impeachment. And I don't know if that's where you're going with this question, Judge Thompson, because sometimes they can. I'm not sure that the government forwarded that argument in this case. I don't think we did at the trial court level. But sometimes it is true that a prior consistent statement can be used to rehabilitate specific instances of impeachment, even when there's no motive to lie initially. There's no motive to lie introduced, and that's from this court's Worthy case.
Thank you.
I did want to say, just sort of piggybacking off what Judge Beckwith asked Mr. Day earlier, that as this court has said in cases like Ventura and Day, prior consistent statements aren't that prejudicial because the jury can understand that repetition does not imply veracity, and that it's only in cases where the evidence is marginal that prior consistent statements are prejudicial in terms of overturning a conviction. And I think that the evidence in this case is pretty far from marginal. You've got 5 witnesses who testify directly about the events of the case. And then you've got a lot of DNA evidence and other physical evidence that corroborates them. So for example, you've got Barbara's blood in the corner of the apartment where this fight happens. And then there's basically a blood trail of Barbara's blood that goes out to the basketball court where the police find a folding knife in a trash can and Barbara's cell phone. And then the blood trail leads back over to Barbara's girlfriend's apartment. And then you have Barbara's blood also on the victim's jeans and on Appellant Glover's jacket. And you've got the victim's blood on Appellant Glover's left shoe and his jacket as well. So, these 3 people are there, they're in close contact with each other. That corroborates the description of the fight, which is Glover, Barber, and McRae fighting against Wills.
Might this be perhaps an unusual case that's a little bit different from the ones that fall under the case law saying prior consistent statements are not that prejudicial? It's because these seem somewhat atypical in that it's not really like, yeah, he said this now, and oh yeah, he said it before. It's a little bit of a cleaning up happening. And and with key witnesses.
Yeah, I don't think that that's a key distinction, Your Honor, because I think that the jury, in fact, heard and saw Manning testify, and they were able to determine his credibility for themselves. And I think just because a detective comes in and says, I talked to this person, here's what they said, I don't think that erases the jury's memory of the actual witness. There's no doubt who the source of the information is, and that person came and testified. And that's exactly why the cases say that the prior consistent statements aren't as damaging or as prejudicial, even if they're not properly admitted.
Mr. Hahn, what's your response to the following argument, which is sort of based on your opponent's arguments, but it's not precisely what they said. There was a discussion of the personal animosity between McRae and Lisa Harrison, the girlfriend of the decedent, and some evidence that in doing what he did to her, knocking her down or whatever it was, and subsequently, pulling a knife and tussling with the decedent and killing him, that all of that had nothing to do with the robbery motive, and therefore to convict Barber and Glover of felony murder on those facts is inappropriate. I'm wondering what your response is. Is your response a factual one, i.e. the jury could believe or not believe the account about the personal animosity and what led to the stabbing? Or is it a legal point that it doesn't matter because entering into an apartment with a gun makes a murder foreseeable, and it kind of doesn't matter how it happened? What is your response? Oh, those are a couple of options, I suppose, but I'm not sure either one is the one you'd choose. What's your response?
Whichever one you like better, Judge Thompson. No, I mean,
I want to hear your answer.
No, of course. No, I think that, this personal animosity, the jury could have possibly drawn the inferences that appellants wants them to draw. But I think that they weren't required to. I think they could have easily inferred from the testimony from these witnesses about how this murder goes down, that it was part of the robbery. Because what happens is that, appellants Barber and Glover come in with guns. Appellant McRae is, telling people to sit down. He's telling Brown to sit down. He stops Ingram from leaving, and then Barber and Glover go to the corner to hold up Wills, and McRae goes to get Harrison. And then when he sees that, when McRae sees that Glover and Barber has started attacking or fighting with Wills, and that Wills is fighting back and maybe even winning given the injuries that Barber and Glover sustained, he goes to the kitchen, grabs a knife, and joins in. And so I think that murder is sort of helping his compatriots when they're embroiled in combat with Wills. He's trying to help them fight with Wills, and they're trying to rob him. There's plenty of evidence about from various witnesses about the things that they say, how they're trying to get either drugs or money from Wills before McRae joins the fight. And so McRae is trying to help them complete the robbery, or at least get away from this botched robbery afterwards. And that, Your Honor, I think is classic felony murder, that in the course of this trying to rob him, they get embroiled into a fight, and Wills ends up dead. I just think, and I'll just want to briefly address this, the sleeping jurors, or the jurors that were nodding off during the trial. I think that in terms of what the trial court did, the trial court, when the trial court's first told about juror 5, who seems to be nodding off, the court takes breaks, and at sort of every point in this discussion about jurors nodding off, the court either takes breaks or asks to inquire, offers to inquire of the jurors, and sort of addresses it piece by piece, making sure that there's no prolonged inattentiveness in this case. And once finally appellants actually make a motion to strike, the judge finds that there was no prolonged inattentiveness. The court notes that it was watching carefully throughout the trial. It called frequent stretch breaks, and finds that there was no prolonged inattentiveness from any of the jurors, or from jurors 5 and 14. And that's why the court denies the motions to strike. In terms of the testimony that they might have missed, I think it's sort of unclear.
Well, was there any, there was concern about the way in which the jurors were asked certain questions that was raised by Mr. Day. Essentially that they were asked leading questions, and there's only one way that they could answer.
Yeah, so I think what the trial court does is the trial court, when observing juror 5 initially and paying attention to juror 5, notes that because everyone is saying that there are problems with juror 5, that the court should inquire, and previews the questions to appellants, all parties beforehand, and there's no objection to it then. And then once the court inquires, it's not only the question, it seemed like you were sleeping with your eyes closed. Was that what was happening? It's also the next question that the court asks, and the court asked both juror 5 and 14 this question, were you able to pay attention and follow the testimony and the evidence? And both jurors say yes, they were. And so, the judge, these kinds of questions are asked in voir dire all the time of jurors. For example, you may have strong feelings about X, Y, or Z. Can you still be fair and impartial to both sides in this case?
But in this
you were
case,
selected as a juror.
I'm sorry, Mr. Hahn. In this case, how do we know that the jurors even knew that? Sort of curious about, the extent to which what the trial judge said makes it sort of a factual finding. Is it a factual finding now that they could pay attention? Because if they were sleeping, if they had fallen asleep, which it really does seem like there's so many references by the prosecutor and the defense lawyer and the judge kind of acknowledging there was sleeping happening. It's kind of hard to imagine how you would even ascertain, at least by asking the person, him or herself, whether they were paying attention.
Well, so I think that the descriptions are mostly that people are nodding off or they're struggling, and whenever that happens, of course, the court takes a break to wake everyone up or get them at least more alert. I don't think there's anyone who describes jurors who are sleeping for prolonged periods of time.
Well, they do. There is a description of their fellow jurors having to wake them up multiple times, right?
Yeah, so that's twice, and that's on I believe that's on June 29th. I think that's right before they voir dire or decide to voir dire juror 5. And notably after voir dire of juror 5, the court notes there's no problems with juror 5 after voir dire happens. But I think that they've noticed that the other jurors are like noticing that the person is nodding off, and they're sort of poking them or nudging them awake. So again, no one is saying that I saw this person sleeping for a long period of time and then I watched a juror wake them up. I think that it might have been incumbent upon counsel, if they saw someone sleeping for a long period of time, to say something about it and to alert the court. And so I think that from very early on, both the court and all the attorneys are very attuned to this issue because they notice it. And so the court takes appropriate steps to address it when it starts coming up again. And if there are no further questions, aside from, I have to admit mea culpa on the merger argument, because counsel is right in the reply brief that we did not charge PFCV counts for the ADWs. So other than merger, I'd ask this court affirm the convictions.
All right, thank you, Mr. Hahn. Mr. Kirsch, we reserved a few minutes for rebuttal for you.
Thank you, Your Honor. I do want to get back into the Winfield issue. Because I believe the position that the government taking is clearly an error. Mr. Hahn, in response to a question, said that the jurors could have put all this together themselves. He was talking about the evidence that was elicited on cross-examination from Detective Weber. And that is, I would submit to the court, absolutely inconsistent with Mr. Glover's due process rights and his constitutional right to present a complete defense. We don't ask jurors to put things together. In fact, jurors are specifically instructed not to speculate. And so the government is saying, well, the jury should speculate because they heard enough, so they could put it together and they can conclude that's what they really meant, they should consider a third-party defense. And that is simply not the law in this jurisdiction or in any jurisdiction. If Mr. Glover had been allowed to present evidence of a third-party perpetrator, number one, he could have asked for a theory of the case instruction from Judge Isco, related exactly to that point. Number two, Mr. Glover could have asked for instruction that if there was evidence of a third-party perpetrator, it's not Mr. Glover's burden to prove that there was a third-party perpetrator. It's the burden remains with the government, and the government still had to prove beyond a reasonable doubt that it was Mr. Glover. The third-party perpetrator would just have been additional evidence to cause the jury to have a doubt based upon reason, a reasonable doubt. So by saying that they could have put it all together, it's completely unfounded. It's completely incorrect. And again, it deprived Mr. Glover, the denial of the third-party perpetrator argument, of the ability to place a very significant part of his defense in this case. Again, his trial lawyer put him in the apartment. So he's stuck with that factually. But the presence of a third-party perpetrator who has a knife, who's on the scene, who's crossing police lines, clearly would have created a reasonable possibility of a third-party perpetrator. And also, the government argues, well, the DNA corroborates the government's case. All the DNA corroborated was that Mr. Glover had Mr. Willis's blood on his shoes. We know from many, many years of expert testimony that DNA can last a long time. You can never time when DNA was deposited. But more importantly, the DNA does not in any way corroborate an intent to commit a felony or an intent to commit a robbery or an intent to commit a murder. All the DNA does is say Mr. Willis's blood was on Mr. Glover's shoe. And again, we don't know when. And I know that there was a question related to severance. And I've just asked if I could be reminded of what that question was.
Sure, it was just that in looking at Mr. McCrae's brief, the other issues, well, let me start again. Both Mr. Barber and Mr. Glover indicated that they adopted the arguments made by Mr. McCrae to the extent they were applicable to them. And then looking at the brief, it seemed to me that all of the issues raised were also raised in one or both of Mr. Glover's or Mr. Barber's briefs, except for the severance issue, which seemed to pertain only to Mr. McCrae. And I just wanted to know whether you agree with that. In other words, does this panel need to address that severance issue?
Thank you, Judge Thompson. And it's my best recollection based on review is that that issue related to Mr. McCrae does not involve Mr. Glover.
Thank you.
You're welcome. And I would submit on the remaining arguments.
All right, thank you, Mr. Kirsch. Mr. Day?
Yes, thank you. Just one correction. April Barnes was an appellant I represented a few years ago. April Fernley was counsel for Mr. McCrae. In reference to the motive to lie for Mr. Manning, I want to point out it's the same. At trial and at the time of his interview with Detective Weber, his motive to lie was based upon his desire for favorable parole treatment. That existed at the time of trial, that existed at the time of his interview with with Detective Weber. The idea that this evidence was strong because there were 5 witnesses is false. All the witnesses other than Detective Weber had issues, and only 2 of the witnesses incriminated Mr. Barber based upon really questionable identifications, not his face, but upon the conversations and upon his body type and based upon type of clothing. The DNA didn't add anything. It's conceded that Mr. Barber was in the apartment. The argument was that he was caught up in the melee and he got stabbed. In the presence of a knife with his blood on it, again, that just confirms what we already know, that he was stabbed.
Mr. Day, can I ask you a question? I may presume, but I don't want to presume what your answer might be. You've talked about how Detective Weber's testimony essentially rehabilitated or inappropriately bolstered the other witnesses from the government who had flaws in their testimony for the reasons you stated. If we're just left with Detective Weber's testimony and the other physical evidence, the knife, the blood, where does that leave Mr. Barber in your view?
If Detective Weber's testimony is ignored?
If it comes in and we don't credit, or we presume that the jury didn't credit the other witnesses, they only credited Detective Weber and the physical evidence.
Well, I think that's a huge problem if that's the basis of their objection was all this hearsay. And the idea that it was an identification. In my end of my brief, I set forth all of the hearsay statements of Detective Weber. It goes pages and pages from all these witnesses, from unidentified sources, from Mr. Manning, from Mr. Hill. There was even one that I left out in the addendum. I did reference it in the brief and earlier today about that the evidence Mr. Barber was one of the perpetrators included speaking with witnesses about what happened that night. But just pages and pages. It was far more than identification. It was every single detail of the government's version of the case. You know, the case of Sims, there was just one piece of information that came in through what this court called a more favorable conduit for the information. You had a witness who had some credibility issues, and that witness wasn't called for testimony about what I believe Mr. Sims allegedly did after a shooting. And they instead called this other witness who had a very favorable background, counselor to kids, and this court said you can't do that. And that was that was error to do so. This went way beyond that, which is this complete presentation of the case through Detective Weber, and that was clearly error.
All right. Thank you. I'd like to thank all counsel for your briefs and arguments today, and the case is submitted, and you're free to exit our virtual courtroom at this time. Thank you. All right, I see counsel for our second case are signing in. Can everyone hear and see us?
Yes, good morning, Your Honor.
All right, Mr. Schifferle, can you hear us? Okay, I see Mr. Schifferle and Ms. Hughes trying to sign on. All right, I see counsel for our second case. All right, Mr. Love, good morning.
Good morning.
I see Carl Schifferle from the Office of the Attorney General, and I also see a Tiffany Hughes. Are they both with your office, Mr. Love?
No, just Mr. Schifferle is.
All right, Ms. Hughes, can you identify yourself, please? Okay. All righty. Our second case for today is Tormel Debus, DDS versus District of Columbia. Are counsel ready to proceed with your arguments?
Yes, Your Honor. Good morning. I'm Anthony Rochelle III, counsel on behalf of appellant Tormel Debus. I would like to reserve 3 minutes of my time for rebuttal in this oral argument.
All right, thank you. You can proceed.
Your Honor, there are multiple issues that have been raised by the appellant in its brief. They are noted on page 1 of the amended brief. I would like to prepare to address those questions that the court may have regarding any of those issues raised by the appellant's brief. But to begin, I want to focus on a few key issues in this case as presented in the briefs. This case involves the request for the release of public records that must be made public under DC FOIA. These are the orders and decisions of agencies. This case is not moot because there was never any document submitted to the appellant for any of the 6 requested items. The reply by the government was late in that it did not comply with the statute's 15-day response. In fact, the government was late by over 3.5 months. And when it did reply, it did not indicate at that time that the documents sought were available on the website. This only came up later at trial. In that document, responding to the document requests, the government insisted upon a payment of over $9,000. The appellant.
Mr. Rochelle, can I start with, I guess, the fee?
Yes, Your Honor.
And from what I understand of the government's brief, and I guess I'd like your response to this, is that, first of all, under our statute, they were permitted to assess a fee, unlike the federal FOIA, where in some instances, if there's a determination that the documents sought are in the public interest, no fee is assessed. Here, our statutory language is a little different and does allow a discretionary call on the part of the government to determine if something being requested is in the public interest and if a fee should be assessed. And so here they determined, arguably exercising their discretion, that the fee should not be waived. And then I know the trial judge spent a significant amount of time parsing through how the fee was determined. And certainly when you hear $9,000, it does raise an eyebrow. But when the trial judge parsed through it, and I guess in determining the summary judgment issue, I believe, there was a determination that it was not unreasonable given that the scope of the request, the amount of time, years of records that they had to search through to satisfy the request. So I guess maybe if you could start there, and then we can take your other arguments about the delay in the response, et cetera.
Yes, Your Honor. Any search by the government has to be reasonable in terms of finding the way that would provide for the minimal amount of costs. The government, in its $9,000 request, never indicated how many documents were going to be provided, didn't indicate how many pages were going to be provided, didn't indicate how that $9,000 was broken out as against the 6 items requested. This is a de novo review with regard
but I think that was not what I understood from the trial court's determinations, that, there was some justification given by the government for the $9,000 fee because the documents being sought, even though there were only a specific number of categories, were being sought for multiple years of information.
Your Honor, the documents that were being sought were electronically produced documents in that they were required to be filed with the federal government in terms of the National Data Bank. Every time a decision is rendered against a health professional, that order or decision is forwarded to the federal government. That's done by computer.
If you were available in the federal data bank, then why did you, wouldn't that lend credence to the district's argument here that they were otherwise accessible? But these documents you were requesting, you're arguing were not available through other sources, contrary to what the district said about some of the requested items.
They were going to the fee issue readily and easily accessible because they had already been produced once before. And under the Freedom of Information Act, the citizen has a right to obtain those documents at a reasonable cost. It just would have taken another computer pointing to make a production of those documents already previously submitted.
Well, I wanted to ask you about that, Mr. Rochelle, and perhaps you can enlighten us. When I looked at the categories of documents that you requested, it seemed to me that some of them would have been produced for this national database, decisions by the board. But you were asking for a variety of other things. I think complaints against dentists, for example, which it didn't appear would be part of what had been produced. How certain are you that every category of document was something that would have been gathered and submitted to this database?
Well, I'm not saying that everything was. I'm saying that the fact that they had already been produced minimized the cost associated with having to produce those. And
well, I guess, and perhaps I'm wrong about this. My reaction and thinking about it was that there are relatively few matters brought to the Board of Dentistry's attention that end up in decisions, whereas there may well be many more complaints that are initiated. So that to say that the relatively small number of decisions have been or should have been forwarded to this database is not really to answer the question about how many other documents there would be responsive to your request and how difficult it would be to search for them. So I wonder if you could address that. I perhaps just am not understanding the point about the database.
Well, the database was trying to identify that this is not a new search. This was something that had been done previously and could have been easily retrieved. The other aspect to this is that these records that are not a part of the database thing, there was no segregation provided by the government to say, okay, I can give you a partial submission for those that and this other bucket of documents, this is the cost associated with it. There was no segregation as to compliance with a timely production of documents. They could have said that in the first email. They did not say, well, on the website, they were trying to discourage any further requests because they put a number out there solely. They didn't break it down saying, these are on the website, these are not on the website, these are going to cost out of the $9,000, $6,000 to allow the requester to determine maybe I need to modify the request. They did not want to do that. They wanted to delay as they did, which was a violation, direct violation, which the court never took up by any finding, which put them in a position of wanting to not disclose.
Is it in fact the case that decisions are on the website, Board of Dentistry decisions?
We could not find them. That's why in the first letter, it was no recognition to us. This case has gone on for 3 years. If you subsequently put documents on the record, again, under the FOIA, which must be made public, eventually they will get on the website. But what's determining here is when the request came in August, whether they were on the website or not. And we are saying that they were not. We would have looked. It's illogical if we wanted them in the urgency for the 2 administrative hearings that we wouldn't have tried to have gotten them through the website, but they were not on the website. We even hired and we brought in a witness, IT expert, to indicate that they had tried to search the website and could not find it. The record reflects that the court even acknowledged that some of the reported decisions were not on the website. But everything that they decide via order or decision is sent to the federal data bank. That's why I was pointing out the federal data bank is that they have a legal obligation absolutely to submit everything, which they have done. And now you have this disconnect as if they haven't done it. They're not, it's not anything that has to be archived other than a computer search. They didn't try to acknowledge that they could put it on a disk or put it on a flash drive or give it in any kind of segregated form. And they refused to provide a Vaughan index, which would indicate how the breakout of what we were buying for $9,000.
Is there a precedent for requiring or creating a Vaughan index for this sort of thing?
Well, no, there isn't. But it goes to the reasonableness of the steps that the government should take to identify the least costly way of providing the documents sought by the public. And
what do you say? Oh, go ahead.
And if you look at what the government has done in reporting to the council every year, as required by the council, there is not one agency that charged more than $500, and no agency totaled in terms of all of the requests for documents in a given year required $9,000 payment. The mayor issued a transparency in government policy, which encouraged nominal fees or no fees. And this is in keeping with what the federal government has adopted. When an agency is late, they have put in place enforcement mechanisms to say that if there was to be a fee, that fee is waived and the document should be made available without fee or with a nominal fee.
Go ahead.
Sorry. Go ahead, Chief.
No, you go ahead, Judge Beckwith.
Okay. I was just going to ask what about their argument that they can't create a Vaughan index until they actually have, got the documents. And right now we're fighting over whether you are going to pay the amount and they weren't going to start even collecting them until then.
Well, but they've already collected them. They have submitted previously to the National Data Bank all of these orders, and they are required by the FOIA, DC FOIA, to make these documents, these orders in particular, available to the public without a request having to be made.
So is your
Well, as
argument,
to the non-orders, we're right back to my question again, though. How confident are you that they've collected these things for the database? Because it just seems that the lion's share of what you're asking for is not material that would have been collected for the database, or that should have been collected for inclusion in the federal database.
Well, the database is very broad. I cited the text of it because it includes more than just orders. It included other kinds of reporting that would allow the public to know what is going on with regard to a licensed health professional. So there's a lot of information that's provided, including the so-called consent orders that we were seeking. Those are required to be provided to the National Data Bank.
it sounds like you're making a different argument, which is maybe that there should be a bifurcation of documents, and they can, sure, there are other things that are going to take resources and time to produce, but they could just perhaps email you these other things and it would cost nothing, and that they should provide those while you're fighting about the fee. Is that the argument now?
Well, that was the argument all along. They never gave a segregation of what was available in terms of disclosure. And the FOIA is a disclosure statute. If they have something that can be disclosed at a nominal cost, they should have identified it. They provided an annual report to the council indicating that for all the government agencies, no one is charged anywhere close to $9,000. And if they had such a cost factor involved, a Vaughan index would have indicated these were the items 1 through 6 that cost X amount. These were the number of cases that you were going to get. These are the number of pages involved. In the Fraternal Order of Police, they've made partial productions. They had to produce emails, and they provided those emails. And certain emails that they later claimed were protected and restricted, they were limited to not providing. So, and in that case, they indicated that there were 1,400 documents, when actually it turned out there were only a couple hundred documents. So,
I'm sorry, go ahead. Mr. Rochelle, I just want to make sure I'm understanding your argument and the relief that you're seeking at this juncture. Your concern seems to be twofold. One, that their delay, and there's no dispute that there was a delay in the government or the district responding to the FOIA request. But your argument is that because they were delayed in responding, that should waive your requirement to pay the fee. And then secondly, that there should not have been any fee. And I guess I start from the reverse, with our local FOIA statute being a permissive statute that gives the district government the discretion to determine whether a fee should be charged in the first place. I don't see your basis. It seems that your only basis for saying that the fee shouldn't have been charged is the lateness in the request. Am I understanding that correctly?
no, that's, with all due respect, you are not correct. I was arguing that one, and in the alternative saying that they denied a fee waiver or a fee reduction or elimination of the fee because they determined it wasn't in the public interest.
Right. So that's a discretionary call.
Yeah.
What would be our basis or the legal basis for us reversing their determination that it was under their permissive statute, not a discretionary, not in the public interest to waive the fee?
Right. Well, under the DC FOIA, orders and decisions must be made public and without a request being made, number one. So to have—
But that doesn't have anything to do with the production of the document pursuant to FOIA being required to waive the fee to do so.
Well, but what I'm saying, if they are under a statutory obligation to have these orders publicly available, and as they claim on the website, which they were not, until we made a demand for them, the public couldn't have had access to these orders because they were never put on the website until we made our request. And our request prompted them to timely now catch up on what was an obligation to do under FOIA, is make those orders and decisions available without request.
Right, but the FOIA, the obligation to make the documents available under FOIA, under our statute, there's a separate provision. It seems like you're conflating two things. That yes, they have an obligation to produce the documents pursuant to a FOIA request or otherwise make them public, but the cost for the ability to waive the cost or impose a cost for these FOIA requests is discretionary under our district government statute, unlike in the federal government where FOIA request, if it's deemed to be in the public interest, there's not the same discretion to waive the cost.
But I have taken the position that orders and decisions of the government are the main vehicles which allow the public to have transparency on what the government is doing. And it's in the public interest where we can have those documents made available by virtue of a FOIA request that should have been made available without our being required to pay for them for future public benefit. Once they are done, they will be on the website for everyone to have, not because we paid to put them on there. It's a transference of the obligation to put the burden on the requester rather than the government, which is supposed to be operating with its activities and operations in a open and transparent manner.
All righty. Are there any other questions before we hear from government? All righty, and we know you've reserved some time for your rebuttal as well, Mr. Rochelle.
Thank you, Your Honor.
Thank you.
Good morning, Richard Love for the District of Columbia appellees. I do want to address the court about the waiver of the fee, but before I address those, I want to respond to some of counsel's arguments, because he's clearly, it seems to me, throughout this litigation, both at the trial court, in his briefs, and in his argument today, he's blind to the scope of his own requests, because his requests for almost 8 years of documents included not just final orders and decisions. His arguments is largely confined to final orders and decisions, and the scope of the request included all complaints that the board received. And we know from the record that the board indicated that in a review of all but 3 years of the request, there were 174 dentists for whom they had complaints. So a large body of information that needed to be was searched and reviewed included complaints which were not electronically available. They're generated by the complainant, not by the board, and they're kept in paper files. And that was repeatedly indicated to Dr. Dubose. Also, the court should note that the argument with regard to the National Data Bank was only raised in a reply brief that Dr. Dubose filed. And the court even noted, and it's at the appendix at page 603. And what the court says is that the National Data Bank issue was only raised in a reply, and it relates to orders and decisions, but that does not end the inquiry. And counsel didn't previously discuss how this reporting requirement would significantly affect cost estimates, and it would not. The other point I wanted to raise was the court specifically said there's no evidence that Dr. Dubow's request forced or prompted the agency to publish final decisions that weren't otherwise on its website. The court held a hearing at which it required the district to demonstrate what was available, and they were able to show that there were final decisions on the website. There's no evidence that was done in response, and the fact that Dr. Dubow's couldn't find them doesn't mean that they weren't there. Moreover, Dr. Dubow's indicated, it's in the record, that he was able to find 9 to 12 decisions on that website. And that number comports generally with his own argument that there are very few decisions that the board has issued since it was created.
Mr. Love, can I interrupt with a question about the standard of review? I always find it interesting that these FOIA cases, there are so many decisions that say these are usually decided on summary judgment, but they often seem so factual. And, you know, in your argument thus far, you've been talking about what seems like a factual dispute over how much the documents that are subject to mandatory disclosure, you know, what part of the overall request is that, or, you know, did that really happen? You know, all of those questions. Is your response to that just that these are just sort of conclusory allegations, or can you say why this is not actually a fight over facts?
Yeah, I think as we argued in the brief, other than Dr. Dubow's conclusory self-serving assertions, made no showing that the production fee did not reflect the actual costs for document search, review, and duplication. And what the district put forward was initially an explanation that identified the locations that needed to be searched, an estimate of the number of hours that staff time that would be needed to search, review, and copy responsive documents, and the hourly rate that the regulations authorize for that staff time. Subsequently, they indicated that the locations to be searched were based on the identification of 174 dentists who, for only a portion of the almost eight year period for which documents were requested, who had a complaint filed against them. Based on this information, they identified 4 different locations which might have responsive documents. They were all paper files, and it was based on those locations that they estimated the staff time, and they came up with the total. There's no evidence that this is inaccurate, and the only argument that Dr. Dubow's belatedly raised was that the estimate has to be high because they're required to send final orders to the National Practitioners Database, and FOIA requires that final orders be posted or published on a website. But as the district repeatedly argued, that's not what was publicly available was not the basis at all for the $9,000 fee. The $9,000 fee was based on a need to review paper files, because the scope of Dr. Dubow's request necessarily required a review of paper files. And it was Dr. Dubow's who is controlling the scope of his request. He's who asked for 8 years of documents in 6 different categories. And the district repeatedly pointed out that the production fee could be significantly reduced if he would narrow the scope of his request.
Can I switch gears a little bit? I think I follow your argument there, but can I switch gears actually completely and ask you a question about your your reviewability argument. I think you're arguing that there is no review from a denial of a fee waiver. And can you talk more about that? I find it, I might be misunderstanding the argument, but it seems that the district is kind of equating a mandatory rule with review and a permissive rule with no review, which doesn't necessarily make sense to me, because of course we have lots of things we review, that discretionary rulings that we review for an abuse. And can you tell, I understand the main point is there's nothing out there saying there is a review, so there must not be a review, but is that necessarily true?
No, but I think our argument goes beyond that. I think what's important here is that, the federal FOIA, which the district's FOIA in many regards parallels, requires a waiver of fees under certain circumstances, and they use imperative language, shall. The district's FOIA did not use that language. So there, I think, is a deliberate choice here to use more permissive language in contrary to the federal FOIA, which DC's legislation often parallels.
But what does that have to do with whether you get review from it?
Well, I think that there was a conscious choice on the part of the council to make this a waiver decision discretionary. It's so significant that they use the imperative shall in various other places in DC FOIA and in the section that provides for administrative review. There's no reference to review of a waiver decision. So I think it's more than just the permissive language. It's all of those factors.
I guess it's, I feel like I'm missing something that everyone else understands, but that if just because it's discretionary, there wouldn't be review. And I understand you're saying it's more than that, but does this mean, what if the only people who got a fee waiver were white people,
Well, then I think, you would have a cause of action for to bring a lawsuit based on discriminatory conduct.
Okay, but you'd have to bring a separate lawsuit because you couldn't complain about that to the Superior Court.
Yeah, but I think, we did not rest on that argument in terms of review being, there not being an ability to judicially review a waiver decision. We point to three different reasons why Dr. Dubose was not entitled to a fee waiver. And the first is that the waiver authority is permissive and not mandatory. But also the regulations require the requester to state in the request letter the reasons. And here, Dr. Dubose failed to explain in his request letter how the requested records would be disseminated, which is one part, which in and of itself is sufficient to deny the waiver, and also to explain how they would be used to primarily benefit the general public. He only made a conclusory assertion that they would be helpful to assessing the uniformity of its decisions. There's no explanation provided. It's simply a conclusory statement, which if under federal FOIA is insufficient. And the ground, if the letter on its face wasn't sufficient to deny it, we know from subsequent filings in this very case that the district had substantial grounds to believe that the records were requested to enhance its ability to earn a living as a dentist and a consultant, and that their disclosure would be primarily in his own benefit, not the general public's benefit. And, the waiver, the public shouldn't bear the cost of a waiver when its primary beneficiary is Dr. DuBose.
Mr. Love, Mr. Rochelle argues that because the district was late, and there's no dispute that there was lateness in responding to the FOIA request, that even if we set aside the district's discretion to impose a fee because the district determined this wasn't in the public interest, Mr. Rochelle's argument is that the lateness alone should result in a waiver of the fee. How do you respond to that? What should be the penalty for the district's substantial delay in responding to the FOIA request, if not the waiver of the?
Well, the consequences set forth in the statute, and that is that it waives the requirement that the requester has to exhaust administrative remedies and allows the requester to file suit in Superior Court for declaratory or injunctive relief. It does not authorize somebody to get documents without the production fees that the statute also authorizes. I think that's set forth clearly in the statute, and it was also set forth in one of the Fraternal Order of Police cases, where it specifically indicated that is the consequence. And I think that's set forth, the site is set forth in the brief. And I also point out to Judge Beckwith one other point in terms of the fee. It's not just a waiver, it's also a reduction of fees. And, there are really no standards, I think, it puts this court, I think, in a quagmire to be evaluating if there's a 10% reduction in the fee. Is that reasonable? A 20% reduction in the fee? Is that reasonable?
Isn't that what happened in one of those FOP cases, though? The court kind of said, well, we need a standard here, and reached to the federal cases and said that's going to be our standard now.
I'm not familiar with that, not in terms of a fee. I don't.
No. Yeah.
A production fee, but yes, you need a standard. In the federal agency cases, there are some standards. I think Dr. DuBose referenced some of those standards in his brief, and in response, we argued, well, those are the standards he has to meet, and really he hasn't met them, even if they were applicable. But I'm going to the point with regard to judicial review. I think that's another element that complicates and speaks to whether or not the council intended to commit this decision solely to agency discretionary action.
Mr. Love, I'm just curious. I don't think anybody's mentioned this, and I can't imagine that it will have a role in our decision making, but I'm just curious. Do you know whether district agencies make any provision for people requesting documents to come in and just inspect them themselves rather than have copies made? Is that ever an option?
Yeah, I think it is an option. The problem here was this required an extensive fee that would require a lot of staff time. And before they would commit to doing that, they wanted payment of the production fee that the statute authorized at the rates the regulations found were applicable. And so, yeah, if the documents, in other cases, I believe that is an option for somebody to come in and documents.
Yeah, I was just wondering what someone would do who couldn't make a showing of public interest, but really needed for whatever commercial or personal reasons to see documents, but couldn't afford the fee, whether that person would be able to come in and review documents in the office. That was really what I was curious about.
The problem obviously is, yes, that would allow a requester to avoid the duplication fees, but not necessarily the search fees. But, again, the requester controls the scope of the request. And here, the request was extremely broad for for a lengthy period of time. There was an offer to come and discuss the matter originally in the letter that the agency provided in response to the request in December. And repeatedly thereafter, Dr. Dubose was advised that the fee could be significantly reduced if the scope of the request was narrowed. It never was. I see that my time is up. I'd be happy to answer any more questions if the court had any. If not, I would ask the court to affirm the Superior Court's decision in this matter.
All right, thank you, Mr. Love. Mr. Rochelle, you have a couple minutes for rebuttal.
Yes, Your Honor, thank you. First of all, with regard to the lateness, what counsel is suggesting is that the reward to the appellant is to be penalized by having to go to court to enforce what the government failed to do in terms of the statute's mandate that it provide the information within the time required. And also, counsel pointed out that the district's FOIA is different, and it's different with regard to lateness compared to the federal FOIA. The council set out a faster time frame in which to have the agencies respond. Rather than 20 days, it was 15 days. And they gave a 10-day extension, like the feds, which the government never requested, to avoid a lateness on their part. And they never followed up to provide for a segregation of saying, look, we can give you items 1 for X cost, item 2 for another cost, item 3 as another cost out of the total of 9,000. They don't break it down. That's the standard that would help provide for a proration, if you will, of what the reduced fee might be. Certainly, the manual production, if there is to be a fee, is higher to produce than an electronic production, which is only a few keystrokes. And they do not put a value on what is the cost of providing all the electronic information that they have versus what is required to be done manually. And we believe that the burden is on the government to have a segregation of costs so as to minimize the cost to the requester as to what is going on. It's like having the requester trying to find out what's in the dark because we don't have access to the files. We have no notion of what's manual versus what's electronic. And in the case of the Vaughn approach, had they provided some separation in terms of what can be produced via the number of files, pages.
Is there any reason why you didn't, or you declined, your client declined the district's offer to sit down and meet with them to more clearly define the scope or figure out if there was a way to narrow the scope and therefore to reduce the cost?
That came late after they had not complied with the requirement. And it was a flat no, and it's a flat $9,000 because it's all intertwined. So eliminating something is still going to be 9,000. We just won't get as much.
Okay.
So there wasn't any real benefit to a process that was always going to require some portion of a manual demand.
Wait,
And
what is the basis for saying it would still be 9,000? I thought the government was representing all along that the scope of the request was the problem, and if you reduced it, the cost would go down.
The request was already segregated into 6 items. There was no allocation by the government as to what made up that $9,000 as applied against the 6 different requests. To provide the resumes of the board members, which was 1 item, is certainly not going to cost more than a couple of keystrokes to provide that information. And agencies do provide reading rooms. The Department of Insurance and Banking has a reading room where a member of the public can go in, review the orders and decisions, seek to have them copied or not. There is no such reading room provided by the government in the Department of Health, although they are supposed to make these things readily available without a request. And we pointed out that the orders and decisions for physicians and other health professionals were on the website, but not for dentists. And we contend what is important with regard to the lateness was that the time of when it's supposed to be on the website was when we filed the request in August, not subsequently being put on the website after the fact or deciding that, oh, we haven't caught up, let's make it available. These are things that they did not have, although they indicated that they were on the website. This notion that the government can say, oh, there is a void of the regulation on the FOIA due to the volume of the request by simply putting a higher fee on that request makes it an attempt to void the production requirement due to a high fee, just like a void for volume. And that's not appropriate under the cases relative to supporting disclosure. And again, under the report that the government files to the council, it not only lists what it collects in terms of the fees collected from the individual requesters, it also lists the costs. And the costs in that report indicates that that cost is absorbed by the government and is far in excess of the fees collected. So the government is encouraging in the other cases to allow for the release of the requested documents without the full payment of the fee. And I would submit that that's discriminatory when we're the only applicant that's asked to pay $9,000 while their own report for every agency in the government lists higher costs.
You say you're the applicant who's had to pay $9,000. Are you comparing comparable FOIA requests to your, or are you just looking at any?
I'm looking at that annual report that looks at the entire government.
Right.
All
those requests comparable in scope and
well, I would
number of documents requested as your request, or do you have a basis for knowing that?
I have a basis for saying that because when you look at the corresponding fee collected versus the cost to produce it, which is in the report.
No, my question is a little different. I don't know if the report that you looked at described the scope of the other requests that were charged for that you're comparing to yours, or did it just give you the total cost of their request?
I'm suggesting that the record speaks for itself when there is a cost associated with the production, which the report shows that is $9,000, but then only collects $500.
I think that's different from my question, but I understand your response. Is there anything further, Mr. Rochelle?
Yes, with regard to the fees, cases have held, even though the documents may not be provided, that if the requester has caused the government to change its behavior and to provide those documents, even though they don't come forward, that is still subject to a fee, given the violation due to lateness. And it's ironic that a government under the council, which calls for a faster production of records, doesn't want to enforce it like the federal government, which has a slower request for production at 20 days, wouldn't want to have the same kind of enforcement applied by the feds in the district when our whole disclosure statute is modeled after the feds. And they have found that in order to incentivize the agency production and release of documents, that they will waive that fee if it is late, or they will still allow for the attorney's fees to be provided for, because that action was the catalyst to cause the government to have to make a timely response.
All right. Thank you, Mr. Rochelle. We'd like to thank both counsel for your arguments and briefs today, and the cases submitted. And you're free to exit our virtual courtroom.
Thank you, Your Honor.
All right. This is our third and final case this morning. Roses One LLC et al. Versus Erie Insurance. I just wanted to make sure that all counsel who've been granted opportunity to argue are present. And I'm going to ask you all to identify yourselves and just confirm how your time is going to be allocated this morning. I will start with you, Mr. Davis.
Good morning, everyone. Good morning, Your Honor. Michael Davis for the Appellant Restaurants. I believe we were allocated 15 minutes, and I'm going to reserve 3 minutes for rebuttal. That's acceptable.
All right. And then I see Mr. Reed, George Reed for the appellee.
Yes, good morning, Your Honor. I believe I just have the 15 minutes.
Okay. And I also see Lori Masters for Rose's appellant, amicus curiae.
Yes, Your Honor. Good morning. I'm arguing for our amici, and Dustin Cho is arguing for the local restaurants amici.
All right, and then I also see, and we allowed
5 minutes, Your Honor.
5 minutes each for your arguments, and then Ms. Laura Fogan. You're on mute, Ms. Fogan.
I apologize, Your Honor. I think I'm set now. On behalf of the amici, APCIA and NAMIC in support of the appellee, I will offer 5 minutes of argument.
Okay, and then last, I see Georgia, and I apologize, your last name is obscured by my screenshot here. So if you could just state your, Georgia Kazakis. Yes.
Good morning, Your Honor. It's Georgia Kazakis on behalf of the amici local restaurants with Covington and Burley, but my colleague Dustin Cho will be arguing. So in order to prevent any confusion, I was going to just stop the video and put myself on mute.
Okay, I appreciate that clarification. And so the amici on behalf of the appellant plan to argue immediately following appellant, and then we'll hear from the appellee and then the amici on behalf of the appellee. All right, well, Mr. Davis, are you ready to proceed?
Yes, I am. Thank you. Good morning, everyone. Michael Davis for the Appellant Restaurants. This case presents a narrow issue of law: how to construe a unique insurance policy containing language distinct from that addressed in other cases, based on facts not disputed below. Let me quickly describe those facts. The appellate restaurants completely lost their ability to serve diners indoors, either sit down or at the bar because of COVID-19. This is not disputed. The DC government determined that those uses were unsafe due to the presumed presence of COVID in those circumstances. The government determined the risk of COVID transmission from indoor dining was too great to permit those normal restaurant operations to continue. This determination had the force of law. It was not successfully challenged by the insurers or anyone else. Violations would be enforced by the police and subject to punishment. The restaurants were thus physically closed to in-person dining, as surely as if the Department of Health had boarded them up.
Can I stop you there, Mr. Davis?
Yes.
You said the buildings were physically closed as if the Department of Health had boarded them up. And I want to start with that as a good example. If the Department of Health had boarded up the restaurant, would the insurance policy with the current language cover the loss? And it seems, as the appellees are arguing, that it would not.
Well, it's our position, of course, that it should and would, because our position is even without them being physically boarded up, they should cover the loss. I don't know if physically boarding them up, if it's, let's say, for example, a restaurant broke the rules and allowed in-person dining, and in order to stop that, the health department boarded them up. I don't know if that would make a difference to Erie, that their counsel would have to tell you. But our position, of course, is yes, that would be covered just as the actual circumstance was covered.
How? Can you walk me through the language in the policy that covers, that would, that,
Sure. Well, of course, Your Honor's question is a good one because the language is the touchstone. And we'll start with the coverage grant. So the coverage grant for income protection says if you sustain partial or total interruption of business, you are covered as long as that results directly from loss or damage to property of the premises. The premises is the
so
restaurant.
we're all on the same page. Could you point us to, you're reading from the language in the Ultra PAC Plus policy?
Yes, it's in the joint appendix, page 79 is that
Okay.
coverage grant.
Okay. Mm-hmm.
And so the question is, what does loss or damage to property mean? Now, I would first observe that loss and damage to property or damage to property is separated by an or. You have loss or you have damage. Thus, based on the normal rules of contract construction, loss must mean something different from damage because they're separated by an or. Erie does not dispute that those rules are applicable here. Otherwise, the two words would have the exact same meaning. You wouldn't be giving meaning to each word. Erie's position, adopted by the court below, is that loss means a whole lot of damage, but that gives it no distinct meaning because any damage, any loss rather, would already be damage. It just means a lot of damage, extensive damage. Our position.
Okay, go ahead.
I apologize.
No, go ahead.
Okay.
Your
I apologize. Our position is that loss means the act of losing possession, the inability to use, or deprivation. And notably, that is really the only dictionary definition of loss that's been quoted in this case. Erie does not challenge it. And that's because we, because we all know.
I have a lot of questions.
Apologize.
I'll start by saying that the appellant's position is very sympathetic. This is, of course, an issue that happened to many businesses here and across the country in light of the COVID-19 pandemic. But I am struggling to sort of wrap the contract around, or the insurance policy provisions around some of the arguments that are being made. So I just want to be clear. You know, when you start talking about the dictionary definitions, that to me makes me think that you're arguing that the language of the insurance policy is ambiguous. And I had understood that, at least before the trial court, both parties were contending that the language of the Ultra PAC Plus coverage was unambiguous, and therefore we don't need to look outside to dictionary definitions or other extrinsic evidence or markers.
Well, Your Honor is correct. It is our position the policy is not ambiguous. However, even for unambiguous language, of course, one can refer to the dictionary because that gives the meaning for the terms. You can still look outside the policy. And in addition, one has to look at all the words and construe the contract pursuant to the normal rules of construction applicable to insurance policies. And furthermore, under DC law, and again, I don't think this is contested by Erie, if there is more than one reasonable interpretation of this phrase loss or damage, then the interpretation favoring coverage must be adopted. The words could have more than one reasonable interpretation, and that does not render them ambiguous in the sense of needing to look at the intent of the parties or evidence not before the court. I do agree with that. But even if Erie's construction was reasonable and if ours was reasonable, because it is a contract of adhesion, our construction must be adopted. That is the one that favors coverage.
Can I ask one other sort of framework question here? There's the commercial liability policy and then the Ultra PAC Plus policy. In construing these documents, are appellants looking at both documents as one whole policy coverage, or focusing us only on the language regarding loss and property damage in the Ultra PAC Plus policy?
Well, Your Honor, the whole policy is the Ultra PAC policy, and all the different types of coverage, whether it's business interruption, which is an issue here, commercial general liability, something else, those are all part of the one policy number called the Ultra PAC policy. So it's all one big policy with numerous different coverage grants, meaning by coverage grants, I mean different areas of coverage, but it's all one policy. And so, yes, we do look at the whole thing. And a perfect example of that is Erie defined property damage as including loss of use of tangible property, that is not physically injured. Now, property damage, of course, is a subset of all damage, right? And whatever property damage means, all damage must be broader because.
Can I interrupt a second? So that definition of property damage, where does that come from?
That is on page 57 of the joint appendix. It is a definition from the commercial general liability.
Okay, so that's exactly why I asked that question, because that seems to be separate and distinct from how different terms are defined in the Ultra PAC Plus policy.
It is a separate portion. Your Honor is correct. It's the CGF portion of the policy.
Ultra portion doesn't define the property damage in the same way.
It doesn't define it at all, Your Honor. That portion of the policy doesn't define either property damage or damage. But my point is simple. It's one policy and it's to be construed as a normal person would read it. And if property damage, completely used in a different section of the policy, I concede that. But as a type of damage, our section of the policy just uses the word damage, right? Which includes property and all other damage. If property damage includes loss of use of tangible property that is not physically injured, surely the broader term damage encompasses that as well.
Can I just ask, I'm sorry, Mr. Davis, property damage is the loss of use of tangible property that is not physically injured. That's weird, right? Can you give me, or it is to someone not familiar with this stuff, but what is a paradigmatic example of property damage without physical injury?
Sure, I can give you some great examples because Erie has excluded some of them from the policy, so we know that they were on its minds. Mysterious disappearance or unexplained loss, i.e. theft, or just the disappearance of something. It's gone, right? It's a lost item. When one loses their dog, the dog is not damaged, it's just lost. Another example would be seizure of property. Again, these are all things that Erie excluded. If the property is seized by the government, it is not structurally impacted, it's just been seized. Communications failure, internet failure, vapor or gases, loss
Right,
of
but
utility service.
the policy at the joint appendix, page 79, defines loss as, quote, direct and accidental loss of or damage to covered property. And then relatedly, the interruption of business is defined at the joint appendix at page 112 as the period of time that a business is partially or totally suspended, and it begins with the date of direct loss to covered property caused by a peril insured against, and ends on the date when the covered property should be repaired, rebuilt or replaced with reasonable speed and similar quality. And so you can't repair, rebuild, or replace something that wasn't physically damaged. And I guess that's where I struggle with these definitions a bit, Mr. Davis.
Well, Your Honor, you're correct about the definition of loss. It does mean loss or damage. That's a pretty circular definition. I'm not sure that it adds much except that it's distinct from damage. We know from looking at other sections of the policy, sometimes Erie just said damage when they meant physical damage. Sometimes they said loss or damage. Loss has to have an independent meaning. Now, Your Honor, in terms of when the period of interruption ends, there's another section of the policy that says it ends either when it's repaired or replaced, or a new location is found. And of course, you can get a new location, a replacement location, even absent damage. Think of my example before of government seizure, right? You can go and get a replaced location. And it ends when either the first to occur of normal business operations can continue, or 12 months. And that's in the joint appendix on page 80. And that is quite different from the language in many other policies. Most other policies don't have the definition of property damage. Not a single reported case that discusses that definition in the context of COVID. There is one from the Eastern District of Virginia, not in the COVID context, in the context of Chinese drywall, that relied on that very definition from the CGL section, different section, to say if the insurer meant something different, they should have pointed it out. That's the only decision I know of. But the other difference with most of the decisions is they don't have this 12-month period. Erie chose this language to say it's either the date that it's repaired or replaced or you get a substitute location, or 12 months. So we never have to repair or replace. We're just capped at 12 months of damage.
You, Mr. Davis, you point to the definition of property damage, which is in, I think, the commercial general liability portion of this Ultra PAC policy. And you make your point about consistency there. What I'm wondering is whether you are reflecting a principle that's established in the general body of insurance coverage case law. And what I mean by that is that it seem to be the law that when you have a policy that has separate lines of coverage, that you are entitled to use definitions in one section of the policy to shed light on or to control the meaning in other sections of the policy. Is that true as a general matter? Because I'm not sure I would have right away thought that it was legitimate to look at the definition of property damage in the commercial general liability section and use that to draw some conclusions about what damage means in the coverage 3 section. Is there some larger principle that I'm missing here or that is established in the case law?
Yes, Your Honor, I think so. And this comes back to my response to the earlier questions about whether this is one policy or not. If it was separate policies with separate policy numbers issued on separate dates, I think Your Honor would have a good point. But this is one policy number. That's how we reissued it.
What though is the point of including a definition for particular portions of the policy? And you'd think one might have a definition section applicable to all coverages. Here are definitions. You know, here's one, property damage. It applies everywhere. But that's not the approach taken. And so I just wonder how legitimate it is to take a definition in one section and say, see, this shows you what the meaning must be of the word damage in another section.
Well, Your Honor, I think there is support for that, black letter law, that you construe the entire policy together, just like you would any other contract, so that all the words have independent meaning. And if Erie had wanted to say, this is a definition only for one section, it doesn't apply in this other section, they could have said that, but they didn't. They say,
well, you know, the point you make about construing documents generally so that words have independent meaning is certainly a fundamental point. I think we can all agree with that. I wonder what we do, though, when a policy contains what you've aptly referred to as a circular definition. You know, we've got a provision that says loss means loss or damage. So what do we do with that? I mean, ordinarily you would say, well, you know, that looks like poor drafting, or you know, loss has got to mean something different from damage. But then we get a definition that says loss is loss or damage. What do you do with that?
Yeah, well, again, we come back to first principles for DC insurance law, which again, I don't think are contested. The Carlisle case and the Richardson case tell us that if there's more than one reasonable construction, particularly for an all risk policy like this policy, right? Where every risk is deemed to be covered unless there's a specific exclusion. And here there's no virus exclusion, even though we were using them in other policies, not here. When you have a policy like that that has more than one reasonable construction, maybe loss means loss of use. That is the normal meaning of the word if you look it up in the dictionary. It's even the normal meaning in the policy, because loss is often mean to be loss of income. Like the policy will refer to loss in that context as well. Everyone, I think, concedes that's a normal meaning of the word loss. So the question is, what does one do when there's two constructions that may be reasonable? And the law is clear that in that case, the reasonable construction that affords coverage must be adopted. And just
I get that point, and I guess what I struggle with here is whether or not the policyholder's interpretation is a reasonable one. I think that's what we have to do, and I too have a number of questions about other provisions. So I sort of apologize for not letting you get back on track with where you're going. But let me ask one or two questions and then yield to my colleagues. So one of the provisions in this policy excludes from coverage loss resulting from acts or decisions of anyone. I've put ellipses in there, imaginary ones, because I removed a few words, but you get the point. We exclude coverage for loss that results from acts or decisions. And then I say to myself, well, there is COVID, and then there is a decision of the mayor to tell restaurants they need to close. And then there is a decision of the restaurant to comply with the law and close the restaurant. And these sure do look like the losses that ensued sure do look like losses that resulted from acts or decisions. Why is that a wrong interpretation, and why is your interpretation reasonable in light of that?
Sure. Well, Your Honor, 2 points. First is that argument was never raised below.
I understand that, but I'm trying to see whether your position is reasonable. So
Correct.
go on. But I do take that point.
Yeah, I just want to make the point for the record that it's been waived. But what that exclusion means, because don't forget, Your Honor, there's a civil authority clause in this policy. Now, we're not relying on it, but basically what the civil authority clause says is if someone else's property is damaged only, they don't use loss there, and there's an order issued that you can't use your property. Let's say there was a fire next door and the fire marshal says you can't use your property next door. That's covered. So and the only reason I'm pointing that out is we know that exclusion wasn't intended to take away the whole grant of civil authority coverage. Otherwise, why put it in the policy in the first place? What that exclusion is for, I would suggest, and again, it wasn't briefed below, is voluntary decisions by the insured that result in a non-fortuitous loss. So for example, if you decide to voluntarily close your restaurant and take a nice vacation overseas, that is not covered. The decision can't be what they call fortuitous in the insurance world, meaning you can't just voluntarily decide as the insured, I'm going to incur a loss because I'm covered. You have to act as a prudent uninsured would. And I think that's what that exclusion gets to. But getting back to Your Honor's question about what's reasonable and what's not, I think we know that our construction of loss or damage to mean, among other things, loss of use is reasonable because many judges from around the country have adopted it. Not all, perhaps not even the majority, but the fact that sitting judges in various different states have said, yes, this is what loss or damage means, like the McMiles case or the North State Deli case or the Perry Street Brewing case. The fact that those judges have said that, I think it's quite strong evidence that it is a reasonable interpretation because
they say, I appreciate some of the cases that you cited to us. I am open to further discussion from you about how the provisions of the insurance contracts in question in those cases line up with the language in the contract here, because I think that those were not necessarily all apples and apples in terms of the basis upon which the judges in some of those other cases decided that the coverage should apply.
That's exactly right, Your Honor. I mean, just to take another example, then I'll talk about the cases in more detail. There's a loss of use exclusion, to get back to the prior question, in other sections of the policy, but not in the coverage grant here, business interruption. There is no loss of use exclusion. So again, if Erie wanted to exclude loss of use, it said it in other coverage sections. It didn't say it here. Again, construing the policy as a whole. But to get to Your Honor's question, most of the cases that have been cited adversely to insureds have an exclusion for pandemics or viruses. We don't have that here. And that's all the court really needed to rely on. And the rest of their rulings, the rulings that go against coverage, are really dicta about loss or damage. Secondly, our coverage end date period, as I pointed out earlier, is not just when repairs are made. It includes replacements, and it has a whole separate section of 12 months. Almost no other decisions have that language. Third, the definition of property damage, not discussed in a single decision that I know of, except for the Chinese drywall case from the Eastern District of Virginia that found coverage in part based on that, but not in a single COVID case is the property damage definition discussed. In fact, it was briefed below, but our trial court judge made no mention of it in her decision. So I think those are some of the key differences between our policy language and the others in many of the other cases. There are other differences too. I mean, suffice it to say, this is a unique policy that was marketed to restaurants to cover, quote unquote, all risks, solely except for those risks which were specifically excluded. Now, Erie did sell a different policy with a virus exclusion, but that's not the one our clients bought. And so for these types of all risk policies, they're very, very different from the policies in the other cases. And the last difference I would point to is a combined policy, as we've all pointed out, an Ultra PAC policy. And so it has many different coverage grants. Most of the other cases are just property policies. They don't have these other definitions.
Now, you said, Mr. Davis, that one of the arguments that you make is that because the virus or pandemic wasn't a specific exclusion, that therefore there should be coverage, even if the property damage language might not clearly cover this instance. We do have some cases that say even all risk policies don't mean any and every risk that was excluded. And so I guess, how do we get around those cases? Is it just by virtue of the fact that you said Erie had an alternative policy, which you did not seek, that did have an exclusion for viruses? Or
I think that's part of it. I mean, I do concede we have to show the triggering language, loss or damage, but that language needs to be construed in the context of the whole policy. And part of the whole policy is it's an all risk policy. They didn't exclude loss of use from this coverage grant. They excluded it from other ones, not from this one. They have the property damage definition. They have loss or damage in the, conjoined with an or. And so for all those reasons, when you look at the language as a whole, our construction, i.e. the construction coverage, has to be at least a reasonable construction.
Well, what's the damage under your construction? I get the argument that the loss is clearly the loss of income and revenue from being able to operate your business. But I don't see what the damage is, because in my mind, it's hard to think about damage if you're not looking at the windows got bashed in, or there was a flood that destroyed the floor, or the stove blew up, or what's the damage here? I can see the loss, but as you just said, you've got to sort of address those qualifying hurdles of loss and damage. And I don't see the damage, or how you're construing what the damage was. Not damages in terms of monetary damages, but what is the damage to the property that was insured? I guess that's how we...
Right, exactly. Well, loss, as you say, is dispossession. So if you have an iPhone and you leave it in an Uber and the Uber drives away, it's lost. You can't use it. damage, putting aside the definition of property damage for 1 second, without that, the policy didn't have that. I would say damage, yes, it means some kind of structural infirmity. So a damaged iPhone would be a phone you drop and the screen cracks. And here we have loss. Under that definition, we may not have damage. You know, who knows? That doesn't need to be decided. But we definitely have loss because we have dispossession. Because again, as I pointed out at the beginning, it's as though the Department of Health boarded it up and said, you cannot use this property. And that's why the exclusions for government seizure or for mysterious disappearance. Why in the world would Erie exclude mysterious disappearance, i.e. something is gone, no damage, if it wasn't covered in the first place? It has to be loss. Otherwise, all these various different exclusions, they don't need to be in the policy. They don't mean anything. They don't ever exclude anything.
All right. Judge Thompson, you mentioned that you had some other questions and I didn't want to.
Well, I see we're out of time. Let me just ask you one more of these questions to which your response will be nobody made that point. And you'll be right about that. They didn't. But as a non-insurance coverage lawyer, even in the past, let me ask this question. And I have a feeling the answer is something everybody knows who practices in this area. Here's the question. The policy refers to loss as meaning direct and accidental loss of or damage to covered property. Nobody spends any time in the brief talking about accidental. That's my question. What does that mean? Somebody's brief does suggest that accidental simply means fortuitous. I did see that discussion, so maybe that's part of the answer. But what's an accidental loss? Is this accidental? Because again, in just ordinary parlance, it doesn't sound like it's accidental because it involves deliberate decisions. What's your answer to that?
Yes, Your Honor, and you're a good insurance lawyer because you've already hypothesized the answer. Basically, fortuitous, what I call fortuitous losses before, not caused by the insured or what are covered. And so accidental means the insured didn't voluntarily elect to do it without some outside compulsion. So for example, if they decided to take a vacation overseas and close their restaurant, obviously that's not covered. But if the fire department shuts their restaurant down, or here, the DC executive branch shuts the restaurant down, that is deemed to be accidental under insurance law. You just can't harm your own property under a property policy. So for example, you can't set fire to your own house, at least not intentionally, right? If you negligently start a fire by smoking in bed, that's fine, that's covered. If you negligently get in a car accident, we all know that's covered, right? The insurance company will pay for your car. But if you intentionally drive your car off a cliff, you cannot collect the insurance proceeds. It's sort of like the suicide exclusion in a life insurance policy. If I could just end very briefly, I know I'm out of time, just in terms of the relief we're asking for is reversal with a directive to that summary judgment should have been entered in the insured's favor. You'll recall below, everyone stipulated there were no contested facts. There were cross motions for summary judgment. We submitted uncontradicted affidavits on all the relevant facts, and the court denied our motion and granted Erie's motion. And we suggest the granting of Erie's motion should be reversed and our motion should have been granted. I'm happy to answer any other questions. Otherwise, I'll go off camera and await my 3-minute rebuttal. Thank you.
All right, thank you, Mr. Davis. Ms. Masters, I think you were going to argue next.
Yes, thank you. Good morning, or perhaps good afternoon to the panel and all on the call.
5 minutes, I think. I'm sorry.
Yes. I wanted to address some of the questions that your honors had raised during the questioning of Mr. Davis. And I hope that my notes are adequate to this. So with regard to your point, Judge Blackburn, your dispute, what is the damage? Is it a reasonable, is the policyholder's interpretation here a reasonable one? First of all, the standard here is that the insurer must show that the policyholder's interpretation is an unreasonable interpretation. And that's specifically shown in DC cases on these insurance issues. On the issue of damage, there's 50 years or more of case law on these issues that shows that instances where there's no structural alteration, no tangible alteration, 50 years of case law that have upheld coverage in these kind of situations, in situations involving smoke, bacteria, landslide, where there's no effect on the actual building in question, odors, situations where there was not any structural alteration, but the courts and the majority rule until COVID was that loss of use without structural alteration was a covered loss under these kinds of policies. And I would like to point out that Erie understood this concept of structural integrity. It didn't require any kind of tangible alteration or anything structural in the insuring provisions, the coverage grants, which are to be broadly construed for the policyholder. Doesn't include any of that. However, interestingly, in another part of this part of the policy, that the Ultra PAC commercial property coverage part, Erie specifically included a definition that referred to this concept. So in exclusion Roman 3B 7B, which is on Joint Appendix 1, I'm sorry, I knew this a few minutes ago, at Joint Appendix 175, there's an exclusion there for collapse, which Erie specifically defines to include loss of structural integrity. The court, in our view, should not now read that kind of concept into the insuring agreement here, particularly in a policy like this, where the policyholder or the insurer who drafted the coverage understood that concept and chose not to include it in the coverage grant language in its standard form. With regard to dictionary definitions, I know Your Honor raised that as well. I wanted to point out I don't have a cite at the top of my head on this, but the restatement of liability insurance. Now, it's liability insurance, but these policy interpretation principles apply across lines of coverage. And in section 3 of the restatement, it talks about the plain meaning rule, which is the first rule of policy construction as adopted in decisions by this court on insurance. But comment B specifically talks about even when you're applying the plain meaning rule with no finding of ambiguity, dictionaries can be used as external sources of meaning for policy provisions. So other external sources of meaning can be court decisions, statutes and regulations, and secondary legal authority like treatises. But definitions, dictionary definitions, are specifically something that courts have typically used in these coverage cases for decades to help interpret what policy provisions mean. And you can see that in the court's decisions here in DC, your court's decisions on insurance interpretation, because those decisions talk about looking to the understanding of an ordinary person in looking at the terms in a policy. So that is from cases like Cameron, American Insurance versus Tut, the state of Korea, cases that we cited in our brief. I would like to say that we submitted this brief here on behalf of United Policyholders and the National Independent Venue Association, specifically to note to the court the potential importance of the court's decision on these issues to policyholders across the country and under all types of insurance and with respect to all kinds of claims, because these principles of policy interpretation are used in other kinds of coverages, as you can see with the decisions in Richardson and Carlisle and Cameron, which involved homeowners and auto liability and general liability insurance. It's also important, we think, to note the fact that DC has specifically adopted the reasonable expectations doctrine. It was adopted in a case called Smalls in 1994, and it's been applied in other cases since by this court in Richardson and Chase versus State Farm, among others. And the reasonable expectation doctrine, of course, says that if there is a question about how the policy should apply, then the policyholder's reasonable expectations should be brought in to confirm coverage. We'd like to also make a couple of points in terms of the arguments that we expect an insurer amici to make here. We think it's important for the court to recognize that a ruling here to enforce coverage will not mean infinite payouts by the insurance industry.
Ms. Masters, can I just interrupt you for a moment to ask
Yes.
a question about something you just said? You referred to policyholders' reasonable expectations. I think one of the briefs refers to their objectively reasonable expectations. Is it necessary to know what policyholders' expectations were? Obviously, they are subject to the objectively reasonable modifier. But do we need to know what the expectations were, and do we know, and is this appropriate for summary judgment?
Your Honor, that's an excellent.
I think I recall seeing in one of the briefs, I cannot recall precisely what was said, but something that suggested that no one had considered whether or not there would be coverage in these circumstances. That may be a misrecollection. So I won't rely on it, but I just wonder whether there were, in fact, expectations about coverage of losses in these circumstances.
I think, Judge Thompson, it's an excellent question. First of all, under the classic formulation of the reasonable expectations doctrine, and I think it's true in the district here as DC, your court, has adopted this doctrine, it is a reasonable person and objective standard. It doesn't require, in my experience or view, a decision on the facts. We think that, especially given that the policyholders here could have bought the policy with that ultra flex form, which had a virus exclusion, that they thought they were paying more premium for a coverage that didn't have such exclusion. They were paying more premium for a broader coverage. But leaving that aside, the reasonable expectations doctrine is intended to enforce coverage when the policyholder has a reasonable interpretation of the policy language and reasonably, as an objective point of view, could have expected coverage to apply. And we think that that's exactly the case here. I would like to say, to get back to my point about whether this decision, a decision here to, excuse me, to enforce coverage would open up this parade of horribles that the insurance industry raises. 83% of the policies, business interruption policies issued across the country to similar businesses have virus exclusions. That is not before the court, and we take no position on how those should be applied. But it's an important fact to keep in mind if the court's going to consider arguments by the insurance industry that somehow this kind of ruling has to be put in place in order to ramp all this back. The other thing to think about is that policies have policy limits. The policies here have limits, and those, of course, cap exposure. And we also really resist the idea that there should be a consideration here in this decision of some kind of extra contractual risk, as the insurer amici put it. If the court's inclined to consider such concepts, it should consider this also. The insurance industry is not reporting losses in this COVID year. They're reporting rising profits and premiums. And also, if the court is inclined to consider those kinds of financial issues, which I think could be considered potentially extrinsic evidence here, then it should consider also the bankruptcy of potentially thousands of small businesses who bought income protection coverage, and we submit reasonably expected that those coverages, those policies would protect them at the time when they needed it most. So to close, I'd like to say that we really urge the court to reverse the decision below. We urge the court to decide this case on its own merits, given the specific policy language here, the facts of the claims here, and the background circumstances, like the fact that there was an UltraFlex policy that Erie, I should say, could have used, that there was an ISO insurance industry 2006 exclusion on the market that Erie could have included here. Any interpretation in our view that goes beyond those facts could have serious effects on other coverages, including homeowners, automobile, disability, and general liability coverages, among others, that have been addressed by this court in their decisions on insurance, like Carlisle, Richardson, Cameron, and others.
Ms. Masters? We've given you additional time. Just wanted to make sure you could wrap up your.
I was finished, Your Honor. Thank you.
Thank you so much. Are there questions, I guess, from either of my colleagues for Ms. Masters before we hear from Mr. Chu? All right, Mr. Chu.
Thank you, Your Honor. May it please the court. Dustin Cho of Covington and Burling on behalf of the amici local restaurants insured by Erie. The summary judgment record in this case is extraordinarily slim because the plaintiffs have focused their summary judgment motion on the mayor's orders. And in our brief, we focus on a different argument from the plaintiffs that the COVID-19 virus, as opposed to the orders themselves, can cause direct physical loss or damage. Now, if the court agrees with that view, the court could examine the evidentiary record here and it might conclude that the plaintiffs are entitled to summary judgment, or it might conclude that the evidence is insufficient to award either side summary judgment at this early stage of the case.
So, Mr. Cho, I was intrigued by the argument in your amicus brief because, if I'm understanding it correctly, it seems to suggest or agree with, or I hate to use concede because that is not what I'm sure you intended, but the concern and some of the questions I have about the language in the UltraFlex policy seeming to imply that physical damage to property is necessary along with any loss. And so your argument that the virus actually constituted some damage to property, is how I was understanding your argument, seems to accept the premise that you do have to have some physical damage to the insured property as well as the loss of income to get recovery here. Did I just completely misconstrue your argument?
That's not exactly our argument, Your Honor. So I think
I was really argument. It was working for me for a minute.
I think I agree with part of your argument. I think there can be really no dispute here, and Erie doesn't dispute it, that the virus can cause physical loss or damage, at least in some circumstances. Obviously, it sold two different policy forms here, one with an exclusion, one without, which would make no sense if the virus could not cause physical loss or damage, at least in some circumstances within the meaning of this particular policy. And I just want to note, since we haven't had a chance to respond to Erie's arguments, their only response is to argue the court can't consider extrinsic evidence unless the contract is ambiguous, but that's just wrong. And it goes to one of the questions that Your Honor asked, the Chief Judge asked my friend, Mr. Davis, earlier. Under black letter DC law, the court may always consider extrinsic evidence regarding the circumstances surrounding the making of a contract. And I would there's many cases that I could point the court to Debnam versus Crane and Co. at 976 A 2nd 197. But in any event, of course, the court may conclude that the word loss is ambiguous as to its application in this specific factual scenario. And I think, Your Honor, to your point, the virus can cause damage, but it can also cause loss. And the case line that I would point to are the Murray case and the Hughes case that Ms. Masters mentioned, and that I believe are in all three of our briefs, about different scenarios in which there is a dangerous physical condition that may not have yet actually arrived on the premises in question, but make that premises unusable or unsafe for its intended purpose. For example, in Murray, there was the danger of a rock slide that made it wasn't necessarily going to damage the building at all, but it made it dangerous for people to live there. And so that was the homeowners there had to move out of their house. They couldn't use their house. They couldn't make their mortgage payments. And the court said that still qualified as physical loss or damage. Hughes, it's a landslide right next to the house. There's also microbial contamination in a well. I think, unfortunately, of course, there have been many cases decided since the briefing here, and we haven't had a chance to respond with a notice of supplemental authority. But for a more recent and extensive treatment of a case that really analyzes these issues, I would point the court to the SWV Yankees v. CNA by the Pennsylvania Court of Common Pleas, which is at 2021 Westlaw 3468995. And that's by a judge who has decided COVID coverage cases both for and against insurers, depending on the policy language and the facts. And I think that's really the key here. So there is a question, of course, if the virus can cause physical loss or damage, at least in some circumstances, and there's no allegation specifically here of the virus on these particular premises, can that still cause physical loss or damage, to your question, Your Honor? And I think that requires this court to decide whether it's going to follow the many courts nationwide that adopted the test in Murray, in Hughes, in Western Fire in Colorado about a gas leak or surrounding the premises that made it dangerous. Does that qualify as physical loss or damage under these policies? And obviously that question has impact, to Ms. Masters' point, that goes beyond COVID. It could be a landslide on the Anacostia. It could be a sinkhole in Georgetown. And the question would be, if someone is forced to move out of their house when there hasn't been a physical penetration onto their structure or into their property, do you still get coverage under those policies? That is the question that's presented by that line of cases. And it's presented here where you don't have the specific evidence of the COVID contamination on the premises that should obviously qualify as physical loss or damage under these properties.
So I hear your argument, and I think this is a consistent theme, if I'm understanding it correctly, between your argument, Ms. Masters' argument, and appellant's argument, that essentially we need to be more flexible in how we read the language loss or damage. And also we can rely on the fact that there was no specific exclusion in the Ultra PAC Plus policy for a coronavirus pandemic or virus of any kind to reach the conclusion that the coverage should extend in this situation.
I think that's right, Your Honor. And I think that's consistent with, for example, the Carlisle decision or other decisions of this court that, previously you mentioned, or Mr. Davis mentioned, that both parties stated that the policy was unambiguous and that there were no material disputed issues of fact. But of course, this court may choose a legal theory that is not slightly different than both of the parties agreed upon, or both of the parties put forward, and that therefore there are material facts in dispute based on the record, and that might preclude summary judgment, or it might lead to summary judgment for the plaintiff. And just to focus on the specific evidence that's in the pretty slim record in this case on our argument that we're putting forward here, the court might decide that the mayor's orders are, of course, they're evidence. The court might decide those are dispositive evidence that at the relevant times, COVID-19 was sufficiently dangerous and threatening to these particular plaintiffs' restaurants at these particular times that warrant summary judgment for the plaintiffs. Or the court might decide that the mayor's orders are not necessarily dispositive. And of course, there could be other evidence as to the dangerous physical conditions at particular times in particular places, and whether those actually made these particular businesses unusable or unsafe for their intended purposes.
Great, thank you, Mr. Cho.
Thank you.
At this time, Mr. Reed, are you prepared to go forward on behalf of the appellees?
I am, Your Honor. May it please the court, George Reed on behalf of Erie Insurance Exchange. I think it's important to perhaps refocus on the narrow issue that is before this court in light of some of the arguments that have been made, particularly by the amici. And I want to go to the complaint because by design, the plaintiffs, now appellants in this case, made it a very narrow issue. At paragraph 8 of the amended complaint, they said it is a single purely legal question of insurance contract interpretation and does not depend on any disputed facts. Does the plaintiff's loss of use of their restaurant properties due to COVID-19 and related government orders constitute direct physical loss under the policies? And then they define what they mean by direct physical loss at paragraph 111 of that complaint. The restaurants have suffered direct physical loss because they have lost the ability to operate properties as dine-in restaurants. That is the issue. The issues that the amici would like to discuss about alternate theories that the virus might have been present. No one ever alleged in this case that it was present on these properties. In addition, no one ever alleged or theorized that the presence of the virus would result in physical loss or damage in any way. The appellants in this case never advanced that argument. This is a case that's here on cross motions for summary judgment. Entirely new theories that were not even alleged, let alone made in the lower court, would be a form of bait and switch we simply don't permit on appeal. And that is precisely what the amici are trying to do here. So what I want to do
on some of the language in the contract.
That's where I was headed to, Your Honor. Absolutely.
I think one might argue that it's not a model of clarity with respect to what is meant by loss of and damage to. Loss of seems to suggest the complete loss of a physical item of property, damage to, some damage but not full loss of. And then you have property damage defined in the commercial liability contract at page 20 of the, or at least my appendix, the way I have it set up, which seems to suggest physical injury to tangible property, including all resulting loss of use of that property. All such loss of use shall be deemed to occur at the time of the physical injury that caused it. Loss of use of tangible property that is not physically injured. And all such loss of use shall be deemed to occur at the time of the occurrence that caused it. And that language in the commercial liability contract seems to me could cover a loss in this situation, except that this definition of property damage is not referenced at all in the Ultra PAC Plus part of the policy. Now, the appellant suggests that the two documents should be read as a whole, and appellees seem to suggest that they're two separate and distinct documents. And therefore, this definition of property damage doesn't carry over to coverage.
That's exactly right, Your Honor.
That was about 6 questions rolled into.
I'll start at the end, Your Honor. And I want to start with where really the court has already started, is this isn't a liability insurance claim. Full stop. So there are definitions that explicitly are applied to just the liability coverage part of this package policy, and there are definitions that apply exclusively to the property protection portion of the policy. And we are focused exclusively on property protection, and that portion of the coverage, that part of the policy, never once by design uses a definition from the liability coverage, including the definition of property damage. Mr. Davis is incorrect that courts have not actually addressed this question. At least 2 cases, the Michael Sita case and most recently the Inns by the Sea case. The policyholders in that case, and it was a case the amici in this case participated in, tried to use the liability definition of property damage in that case, and by way of a footnote 16 in the Inns by the Sea case, the court quickly dispensed with it because of the very point we've all been making, really, the court and I, and that is that this is not a liability insurance claim, and liability insurance definitions don't apply to a property insurance claim.
Well, let's just unpack that just a little bit.
Sure.
If I look at the definition of property damage, subpart B that I just read, loss of, which you say is in the commercial liability portion, it says loss of use of tangible property that is not physically injured. All such loss of use shall be deemed to occur at the time of the occurrence. So if I read that, I say to myself, here, the occurrence was the mayor's order closing down restaurants and other businesses because of the public health and safety cause issue brought on by the coronavirus pandemic. So that language seems to fit nicely to me. I want to use that. I'm tempted to use that here because
Your Honor, if
you buy insurance for especially an Ultra PAC Plus package, thinking that you're protected, surely, I guess, if that language were in the Ultra PAC portion, just humor me for a second, wouldn't it cover this situation?
Well, I can't even answer that question properly, Your Honor, because it's just a completely different context. I mean, if the policy were to come out simply and say, full stop, we cover loss of use, we'd be in an entirely different case than we're in. But you have to remember that this definition is meant for the situation where one of the restaurants in this case does something on its property to perhaps burn down the adjacent business, and then that business sues that restaurant, not just for the resulting physical damage, but for any consequential damages, including damages resulting from loss of use. So what this really makes, what this definition, the point it really makes, is that if Erie intends to ensure loss of use, it comes out and says so. It never does that, except, as I'd like to discuss here in a moment, as one of the links in the chain for purposes of the business income protection coverage. So I'd like to go to, I think, what was one of your first questions, and I want to actually go to the points I'd like to cover, if I can, this afternoon. I think what really the appellant restaurants are trying to do in this case is rewrite the insurance policy to create coverage where none exists in a number of different ways. And they do it, first of all, by the provision that Your Honor referred to, and that is by effectively rewriting direct physical loss of or damage to covered property. And I'd like to explain what I mean by that. So that is a phrase now that literally hundreds of courts have considered since Judge Higashi did in August of last year, and the vast majority have interpreted that language just as she did. In fact, that includes every appellate court to date that's considered it, the Sixth Circuit, Eighth Circuit, Ninth Circuit, 11th Circuit, and most recently, an intermediate appellate court in California in the Inns by the Sea case. And I will say this, I'm sure the court feels the same way counsel do in this case. With hundreds of cases, you sort of have to pick and choose which one you read. And the one I would commend to the court is the Inns by the Sea case. It came out just 2 weeks ago. It covers all of the issues very thoroughly based upon all those hundreds of cases that I've mentioned. But of the courts that have considered what that phrase means, rather than just deconstructing singular words, they interpret it cohesively, and they speak in terms of a continuum. And on one end of the continuum, we have property that is untouched, unharmed, undamaged. And on the other end of the continuum, we have the total loss situation, where the property has been totally destroyed or perhaps stolen. If you think of a fire as it progresses, obviously when the fire starts, there's a small amount of damage, but as it progresses and the damage becomes more severe, if we're using the word loss in the ordinary popular sense of that word, as we are required to, people would actually start to say that that building was lost in the fire even before it was totally destroyed. And that's why the concept of loss and damage overlaps. But you do eventually get to the total loss situation, which was both parties talked about as the iPhone example, where it's either totally destroyed or it's been stolen. The problem for the appellants in this case is they never left this end of the continuum. The condition of their property did not change from the moment before Mayor Bowser issued her orders to the moment after. And before that order was issued, there were limits on the use of their property as well. There were limits on maximum occupancy. There were fire protection limits. There were health code limits. After the orders were issued, it was still usable. It just was subject to additional limits. And that's why if we actually focus on the context of physical loss, as I'd like to, we understand why that trying to make this mean loss of use doesn't work, because that's what they have to do. They have to try to make the word loss, to avoid having never left that end of the continuum, mean loss of use or even a more limited use, which is really what we're talking about. If the word loss can mean a number of things, if we go to the dictionary, it can mean, I can say I lost a game or I lost a friend, but we all quickly dismiss that meaning of the word because of the context. Context matters, and the context here is direct physical loss, and the appellants fail a very simple context test. If I am standing in front of the burned remains of my restaurant and I say I lost my restaurant property, everyone knows what I mean. But if I am standing inside my fully intact operational restaurant with cooks cooking food in the kitchen and customers picking up takeout at the front door, and I say I lost my restaurant property, it makes no sense whatsoever.
Where does the loss of income and the loss of revenue come in? Is that under loss or damage, or where is that? How do you factor that in? How do you contextualize the coverage here?
Well, if I could I will come to that question, Your Honor, but I'd just like to complete that thought, and then I will go straight to the income protection language, because that was where I was headed next. What the appellants do is they always refer to their loss of their property, or they always say, I'm sorry, they always say that they have lost the use of the restaurant property. They never simply say they lost their restaurants. If you look at the briefing, if you listen to their argument today, they always have to add the words of and use. And the problem is those words aren't where they need them to be and want them to be to create coverage. So what they really want to say here is that a physical loss, direct physical loss of property, can mean simply a more limited use thereof. And that somehow triggers coverage. And that is simply not what this policy says. But to turn, Your Honor, next to the language you're pointing to, I want to go to, I think this is page 79 of the appendix, the income protection coverage, the first sentence thereof. Income protection means loss of income and or rental income you sustain due to partial or total interruption of business, resulting directly from loss or damage to property on the premises described in the declarations from a peril insured against. Now, I want to focus on the links in the chain here. A direct physical loss has to in turn cause the defined term we'll talk about in a minute, interruption of business, effectively a loss of use, that then in turn causes, Your Honor, the loss of income, the loss of revenue that would be covered if the interruption of business causes such a loss. The problem with their interpretation here is that if we plug in loss of use where loss is here, and we say you sustain that the loss of income you sustain due to partial or total loss of use, because that's what that is, resulting from loss of use, suddenly loss of use becomes both cause and effect. They collapse the two chains, the links in the chain, into one. It simply makes no sense. It renders it superfluous. That's why when you start to sort of use these square peg round hole concepts, just using dictionary definitions, the house of cards comes down pretty quickly when you actually apply it throughout the terms of the policy. The same thing happens with the definition of interruption of business. And there, I think we're at page 112 of the appendix. This provision is the beginning end of the loss of use. It begins on the date of direct loss to covered property, and it ends on the date when the covered property should be repaired, rebuilt, or replaced. Now, there's nothing to repair here. There's nothing to rebuild, and there's nothing to replace. So consequently, if we take their interpretation and apply it to this policy as written, there's no end. What they really want this court to do is add another R word. They want to add reopen.
What's your response, though, to their 12-month point? Because they point out the next clause. You know,
I was going there next, Your Honor, so thank you for that. I will actually, for this purpose, go to their reply brief. Because to be clear, I want to lose that point. That provision I just mentioned falls apart and becomes superfluous, as many courts have concluded already. But I do want to move to this amount of insurance provision, because the best way to consider it is at page 10 of the appellant's reply brief. The court should know that this is the very first time in their reply brief that they advanced this argument. It was never advanced before, but I'm nevertheless happy to address it, because you'll note with interest the language they choose to emphasize. They put in italics certain words in the first clause, and they skip entirely the first of the two prongs. But if you actually read it together, this is what happens. It has to be the shorter of the two. The first is the time period required to repair, rebuild, or replace. Well, there's nothing to repair, there's nothing to rebuild, there's nothing to replace. So the time period would be 0. The second prong is 12 months. So if we are actually applying this as written, the shorter of the two is no time. So this doesn't help the appellant's cause at all. In fact, if this court were to even accept their theory of the case and say that loss of use can mean loss, even if you accepted that, the loss would still be 0, because the shortest time frame, since there's nothing to repair, rebuild, or replace, would be 0. The other provision the court's we've already touched on, I just want to touch on it again briefly. They are asking the court to move, essentially, rewrite the policy to move the definition of property damage from the liability coverage and then use it in the property coverage. That's, we believe, inappropriate. I would like to touch on one point Mr. Davis makes, sort of a backhanded extrinsic evidence thing about it, this purportedly being unique. If this court were to do a search on Westlaw for a property damage definition in the context of liability insurance that included loss of use, it would find thousands of examples, because that is precisely how insurance companies define the term solely for the purpose of liability insurance coverage. It is not unique in any way.
What's your response to, I don't know if you were finished with that point.
I am, thank you.
The response to the argument that, coverage for a pandemic or virus was specifically not excluded in this Ultra PAC Plus policy, and which they chose to purchase, and it was specifically included in other insurance coverage options that Erie offered.
Well, Your Honor, I first of all do believe, and I completely disagree, I have to say, with all due respect, with Mr. Cho, I don't think you can consider extrinsic evidence to create ambiguity where there is none. But this is really a belt and suspenders situation. It is not a concession by any stretch that an insurance company includes an exclusion. It's simply acknowledging that creative lawyers who have monetary motivation, as the DC Circuit indicated in the Atheridge case a number of years ago, they can make words mean lots of different things. And so when a carrier adds an exclusion, it is because of the possibility that a claim might be made for something that's inconsistent with the intent of the policy. The intent of this policy is to only cover direct physical loss of or damage to covered property. There is no need for adding a virus exclusion if the insureds cannot first establish that. What's interesting, Your Honor, is that courts actually have had, there have been a number of cases where courts have had both, of course, the direct physical loss issue and the virus exclusion. Many of them, including the Sixth Circuit, have simply opted to focus only on direct physical loss, having not found it. They don't even consider whether there was a virus exclusion or whether it was applicable, even though it was right there for them to use. Many, many courts you will find have done that, because you don't look to exclusions if you don't first find something that needs to be excluded. There is no need for a virus exclusion in this case.
Here we sort of have the inverse of the argument, if I understood the appellant's argument correctly, that it's not an exclusion here. And if as some of our case law suggests, where there are reasonable differences in interpretation of the language of the contract, some deference is owed to the insured. And also, I'm paraphrasing what I think were appellant's arguments. So appellant and anyone else can correct me, but also here in some circumstances where coverage is not specifically excluded, which it isn't in this Ultra PAC policy, that's also something to view in favor of the insured interpretation of why coverage should be extended.
Well, I think Judge Higashi got it exactly right, Your Honor. And that is that unless an insured first carries their burden of bringing their claim within the coverage provided by the policy, there's no need to even give thought to an exclusion because there's no coverage to exclude. And courts do not create coverage where none exists simply because an exclusion isn't there. There still has to be direct physical loss of or damage to covered property, and that's where this case fails. What insurance companies have done, Your Honor, is because creative arguments can be made, some have opted to adopt virus exclusions. But what's interesting is insureds, if there's a virus exclusion, will focus on the orders and de-emphasize the virus. But if there isn't a virus exclusion, they want to emphasize the virus and de-emphasize the physical loss or damage issue. The bottom line is that it is belt and suspenders. And so what insurance companies have done is in some instances, they protect themselves with just the need for direct physical loss or damage. In other instances, they've added a virus exclusion to add additional protection. And courts have routinely recognized that the two are complementary because some courts will rely just on the absence of direct physical loss, and others will rely on just the virus exclusion, and others will rely on both. The last point I'd like to make, yes.
No, please go ahead. Make your last point, and then
Thank
I'll
you.
ask my question.
Thank you. What they also are really trying to do here, I think, by way of a rewrite, is really rename the policy to change its character entirely. And by that, I mean this is property protection. It is not operations protection coverage. I mean, again, we have to remember that before anything happened here, these restaurants were subject to limitations on occupancy, health code, and other things. If we were to suddenly dispense entirely with the need for any nexus between a loss of income and actual physical loss or damage, as they're proposing here, then if the district were to suddenly decide that one of these restaurants, the maximum occupancy should drop, well, that's a further limitation on their use. So I guess that's going to be a covered event. In fact, I can think of many instances where if we were to have snowstorms, if we were to have parades, if we were to have protests, anything that would result in a limitation on their operations, keeping in mind that these restaurants continued to function and serve delivery and takeout, any limitation would suddenly result in coverage. That is the kind of sweeping expansion of insurance coverage without any manageable bounds that one California court in Plan Check Downtown talked about, and that this court should not give into. They should not rewrite the policy to expand it in that way. I'm sorry, Judge Thompson, your question?
Yes, and I just wanted to ask a much more mundane, kind of mechanical question. Your position would be that the language in the commercial general liability portion of this policy is not controlling. We don't look to that. Although, as I understand it, that is part of the Ultra PAC policy. Is that right? It's a subsection. What I want to ask you is this: Are you able to tell me, just from your notes there or whatever papers you have in front of you, what pages of the joint appendix would you say contain all the language we need to look at? There are a couple of policies in there. There's Buttercream and then another policy holder. But there are many, many pages of policy language that you would say is not relevant. And I wonder if I can do this myself, but if you have to know the pages you think are relevant, I would appreciate hearing them.
It is Exhibit A to the original complaint that was filed in this case. It starts at page 37 of the appendix, and it appears to end at 129.
That's it?
Yes.
In your view? Okay, thank you.
I'd like to just close with one thing, and this is straight from the Sixth Circuit's recent decision in Santos Italian. The court concluded by saying that the reality of insurance is that it's not a general safety net to all dangers. Efforts to push coverage beyond its terms creates a mismatch. An insurance product that covers something no one paid for, and worse, runs the risk of leaving insufficient funds to pay for perils the insured did pay for. That is why we must honor the coverage the parties did and did not provide for in their contract. And that is why we are asking the court to interpret and apply the contract as written, decline to rewrite it to create coverage where there is none, and affirm judgment in Erie's favor. And
that reminds me that I wanted to ask you about the point made in one of the briefs, which is that Erie promises as near perfect protection and perfect service as is humanly possible. Citation is to Joint Appendix 207, which is not in the page range you gave me, but so I guess you don't think that controls, but regardless of that, is that relevant in our quest to determine whether the policyholder's position is reasonable?
Your Honor, anything that's in that policy is fair game for this court to consider, but for all the reasons I've talked about, if we consider it as a whole, there is no direct physical loss and no coverage in this instance.
And you excluded that page because it's not part of the policy language?
I'm sorry, Your Honor, I certainly didn't intend to exclude anything I shouldn't have. I was really just going based on Exhibit A, but I'm sorry, where is the language you're referring to? I'm happy to answer the question.
I'm looking at one of the briefs. I don't know whose brief it is. It's I'll go back and tell you in a minute. It's page 1. It refers to Joint Appendix 207, and it says that Erie promises as near perfect protection and as near perfect service as is humanly possible. And this is the appellant's opening brief. That's what I'm looking at. So I guess my question just is that language on Joint Appendix 207, is that something that ought to be part of our consideration if we're looking at the language that you think is relevant?
If what you're pointing to, Your Honor, there's 2 copies of the same policy in the appendix.
Mm-hmm.
If it's on page 207, and I'm not seeing it at the moment, that is part of the policy. It's just a duplication of the policy I referred to earlier.
Oh, all right. That's fair. Thank you.
Let me ask a question that admittedly may not be as fair, but I'm going to ask it anyway. Part of what's so troubling, and I think in some of the cases, I haven't read all of the cited cases across the country that have addressed this issue, is, if I'm a business and I buy an Ultra PAC Plus insurance policy with all of these promises and clauses to cover me, and I find out that I'm not covered in my most urgent time of need that none of us could fully foresee happening. That's troubling. And I guess I'm curious. Here's the question that I said, sort of philosophical, maybe not entirely fair to Erie, but what kinds of COVID-related claims has Erie covered insurance for?
Your Honor, I don't believe that there is coverage for COVID-related claims in the property insurance policy. That's why it's been denied. It's not. It's your larger question.
Yeah, my question is larger. Did they cover any kind of arguably COVID-related claims in any of their liability policies to businesses? So nothing related to COVID is covered by any of your policies like this one, the Ultra PAC policy.
Your Honor, I'm not.
Some losses.
Maybe this isn't a fair question, Your Honor.
No, I know it isn't.
But I will say. Let me nevertheless take a shot. I have not given a moment's thought to what coverage the liability provisions would provide for COVID, so I can't answer your question. It's just not the issue in this case. And I suspect that the other lawyers on this Zoom conference would also concede that most of us specialize in one or the other, property insurance or liability insurance, and mine is property, so I can't speak to the liability portion of the policy. I can say, Your Honor, that there is that from Erie's standpoint and based on the policy as written, there simply isn't coverage for the loss of income claim that's been made in this case on these facts, and that's what I can answer.
I told you it was an unfair question. Sorry. More philosophical than not, because it is concerning.
It is absolutely a concern. And I think that's why the Sixth Circuit comment that I closed with, or tried to close with, was so good, because it is a hard reality of insurance that it is not a general safety net for all dangers. It can't be. Insurance would be far too expensive if it tried to be. So
all right.
If there's nothing else, I have nothing further.
All right. Ms. Fagan, I'm sorry if I'm mispronouncing it.
No, thank you very much, Chief Judge. It's Laura Fagan on behalf of the American Property Casualty Insurance Association and the National Association of Mutual Insurance Companies. And I'd like to start with a question that you just asked and see if I can offer a little bit of perspective in that regard. There are many, many payments that have been made by insurers in relation to COVID claims. For example, obviously in health and life insurance, but particularly in the property casualty context, in the context of workers' comp claims. I mean, there have been very substantial payouts by insurers. There are other kinds of policies that may respond to some claims in the liability context. You know, we're seeing that there are claims made based on employers' vaccine policies. And, you know, there's so many different issues that can arise. There also have been claims made against boards of directors for allegedly, you know, misrepresenting the likelihood of vaccines from, you know, certain companies, and there may be D&O coverage in that context. There are all kinds of issues that can present covered claims. And so I don't want to walk away from that question in the sense that no, insurers have just denied and haven't faced any exposures because of the COVID pandemic. That's simply untrue. They have faced very massive exposures, but those exposures are not properly within the property policies. And that's really, you know, the argument here. I also want to take up for a second one of the comments that was made by counsel for one of the other amici about insurers, you know, allegedly profiting in this time period. And that's also, you know, simply not at all supported in the record. And in fact, overall losses worldwide from natural catastrophes in 2020 totaled $210 billion, significantly higher than 2019. There were 980 events that caused those kinds of losses in 2020 that were within property policies. So property insurers are not walking away from problems that are covered under their policies either. I mean, from, you know, hurricane, I hate to say it, but Laura, which was the major 2020 hurricane event, to the California wildfires, to a dangerous derecho that hit the middle of the country, there have been very, very substantial property losses. What those property losses have in common is that they involve physical damage to property. And that's very different from what we have here. What we have here is something that is quite different from that core concept of, from start to finish, what has been described by the Sixth Circuit as the North Star of commercial property insurance, namely direct physical loss. And that direct physical loss language is what permits insurers to price and underwrite property coverage. It's based on that concept that you've got some harm to property. That's the centerpiece of the property bargain, the property arrangement that's made. And, you know, there's some really interesting language in the brief of the appellee. And I know we've had some quotes from it, and I would take the court to page 5 of the brief of the appellee, which talks about the property portions of this policy and says there are 3 components to them. There is the coverage for building damage to buildings. There's the coverage for damage to personal property. And then there's the coverage for income protection. And the brief says only the income protection coverage, which is the portion providing insurance for business interruption, is directly at issue in this appeal. And that is the beginning and the end of the case right there, because the policy does not provide income protection coverage writ large. It only provides income protection coverage where that loss of income results from physical loss or damage to property. And that component isn't there. And therefore, the policy doesn't provide income protection coverage in this incident. Those kinds of coverage, income protection and extra expense, are supplementary coverages that arise in the context where there's physical damage in the first instance. If your restaurant burns down, you are covered for loss of use, but only, and for income loss as a result of that, but only because you started with direct physical loss to property. That's the linchpin. That's the way the coverage works. And if you look at the coverage language, if you look at the income protection language, it says very clearly that income protection means loss of income or rental income you sustain due to partial or total interruption of business resulting directly from loss or damage to property on the premises. So it's not just in general income protection. It's income protection where that loss comes directly from loss or damage to property. And that's the core of the whole case. There have been a bunch of questions about how the policy operates as a whole, and I do want to take on a couple of those quickly as well. There was a question about looking at the CGL portion of the policy and the definition of property in the CGL portion of the policy. And I want to be clear that this policy contains some provisions that apply to the entire policy. For example, if you look in the policy, there's a section called Common Policy Conditions. And it starts off saying all coverage parts included in this policy are subject to the following conditions. So the policy explicitly distinguished between those provisions which apply to all of the policy coverage parts and those that apply to particular coverage parts. The language of the definition of property damage in the CGL policy clearly doesn't apply to the property policy, and there are several reasons why that's true. One is, as you were reading it and going on in an earlier question, we noted that it's about everything that results from the same occurrence or something with respect to occurrence. And occurrence is a liability concept. It doesn't appear anywhere in the property coverage. It's not the basis on which property coverage is underwritten, which is covered perils, whereas liability coverage is written on an occurrence basis or a claims made basis, here on an occurrence basis. So that's telling you that that definition relates to the liability coverage when it uses the word occurrence. It's also telling you it's not applicable here because it talks about loss of use of tangible property that is not physically injured. Yet when we talk about property damage in the property policy, we talk about direct physical loss. So we're talking by definition about property that is physically injured. So again, we know that other section of the policy doesn't apply here and doesn't make sense here.
So where, how do we make sense of loss and damage to language? Because to get to the interpretation that you described so eloquently, there's words missing from the document that don't say what you just said. So what language do you, why is it that we can make that leap by looking at loss and damage to?
And Your Honor, respectfully, I would say that there are some words missing when we talk about loss or damage to. And that's because the policy starts with this concept of direct physical loss of or damage to. And those key words, direct and physical, that start off the insuring agreement of the policy are really part of that linchpin. You know, how do we make sense of loss or damage? We don't just take those words out of context and say, what does loss mean to you? We say, what does loss mean in the context of this policy? And where the word appears is right after direct physical loss. And in the context of, potential interruption of business operations that has coverage that ends when the property is rebuilt, restored, replaced, because we're talking about that kind of physical injury to property, direct physical injury to property. And that really is the core, and it's the core that permits this type of coverage to be underwritten, as well as, makes sense of the restrictions that are being described by the appellee here. And I just want to give a couple of examples. First of all, I'd like to draw the court's attention, and I know it's in the briefs, but it hasn't been mentioned in the arguments today, to cases like the Brothers Insurance versus Liberty Mutual Fire case, which is, of course, a DC Court of Appeals case, 268 A. 2nd 611 from 1970. And there are two other companion cases to it, the Caesars Corp versus Jefferson Insurance and the Max Pipe and Drum versus Northern Insurance, all of which were decided in the aftermath of events following the assassination of Martin Luther King Jr. And what happened at that time is that there were specific restrictions on the operation of businesses and curfews. And those restrictions included, for example, closure of bars and limitations on sale of alcohol, as well as general curfew closure restrictions. And property insurance claims were brought by businesses who could not operate in their normal way of selling alcohol or having patrons in the business at various hours. And the answer that the DC Court of Appeals reached at that time, and that I would submit remains true today, is that those kinds of governmental restrictions, which undeniably impact businesses, they are not what is covered by property insurance. They are operational limitations, they are economic limitations, but they are not property losses, insured property losses. And the court found that reached that exact conclusion with respect to those examples of, government restrictions on operations before. And I think those cases still hold true today. And they're very important recognitions of how that coverage works and what its limitations are.
All right. Are there any questions or comments from either of my colleagues?
No.
All right. Anything further, Ms. Fagan?
I see my time is up, Your Honor. I'd love to go on, but I have to be respectful in that regard. Thank you very much.
All right. Thank you very much. We reserved a couple minutes for your rebuttal, Mr. Davis.
Thank you very much. And thanks to all of you for taking time on these important issues. I'd like to pick up on something Erie's counsel said. He said if the policy said we cover, quote, loss of use, then yes, they would acknowledge there's coverage here. But essentially, that's what this policy does. First, they sell two identical policies, one with COVID coverage and one without, and he says the one with gets us nothing more. I respectfully submit that's ridiculous. They knew how to exclude loss of use from viruses, and they did not here. Secondly, loss or damage. Loss cannot possibly mean only damage. Why use the two words? For civil authority, they say only damage. No one thinks a lost dog is a damaged dog. That's just not what the word means. Moreover, they exclude loss of use from other coverage grants, specifically from other coverage grants. They do not exclude loss of use here from this coverage grant. That coverage is given. It is not excluded. This is an all-risk policy. They have the duty to exclude specifically anything not covered. They knew about it. They excluded it from other coverage sections. They don't do it here.
Can I interrupt? What about Ms. Boggan's point that you keep leaving out the direct physical modification of the word loss?
We briefed direct and physical extensively, both here and below. I only left it out because candidly, there's never been any serious challenge to it. It's definitely direct. No one disputes that these orders are the sole reason, the orders and COVID, the sole reason we were shut down. There's no intervening factors. We didn't run out of employees. We didn't run out of raw ingredients. Diners didn't voluntarily decide not to come. It's directly required by law, mandated. The executive branch made the decision this is unsafe. It is physical because this isn't some unnamed fear. We were prohibited by law from having customers dine in. That was enforceable by the police and by fines and penalties. It's physical, as I said at the beginning, just the same as we have been boarded up. And I have not heard that challenge. The only challenge is Erie wants to say, well, you can still make some use of the restaurants, but that is immaterial. The policy
Is that, I'm sorry, are you now responding to the analogy Mr. Reed was drawing between your loss and, occupancy limits?
Yes.
What do you make of that?
Yes, exactly. I think with all due respect, it's misguided. The policy provides that the loss of use can be temporary and that it can only last as long until you can get back to normal use, meaning it does not have to last forever and it does not have to cover everything. The policy does not say we only cover complete and total loss of use. And if you can make partial use of it, then you're not covered at all. No, that's worked out when you get to the quantum of coverage. What are our damages? And if we were able to make some minimal income from takeout service, as many of the restaurants were, then fine. And that would be a deduct from their claim. Moreover, there's an affidavit in the record, for example, Joint Appendix 162, but there's one from every single claimant, attesting to the truth of every single allegation in the complaint relating to those restaurants, including their inability to use them for their primary purpose. None of that was disputed below. Erie never said, we contest these affidavits. Both parties said everything in the complaint is deemed to be true, but there's still no coverage. That was Erie's position. And that can't possibly be right. Finally, I want to note that the pages counsel for Erie reference as being relevant, 37 through 129, that is the entire Ultra PAC policy from beginning to end. It is one policy with one declarations page. They might want to run from the property damage definition, but they put it in there. And look, you don't even have to carry that definition over. Just think about common sense. Is property damage a type of damage? Yes, of course it's a type of damage. It's got damage right in there. It's damage to property. What's covered in our coverage grant? Damage. Damage, unmodified, has to be broader than property damage because there's damage in the world other than property damage. It's as simple as that. Could a reasonable person reading that language, not seeing an exclusion for loss of use, paying extra for COVID coverage, could a reasonable person think, as many judges have held, that covers me? I think the answer is yes. Finally, just alluding to the prior case law, the riot cases, those policies were totally different. The language was totally different. The primary language there was damage to or destruction of. Damage to or destruction of, not loss. They could have used damage to or destruction of here, fine. But they didn't. They didn't do that because our losses are covered. Thank you.
All right. I think that concludes our arguments for today. I would like to thank all counsel for your briefs and arguments. I'd like to thank amici counsel on both sides of the issue for your briefs and arguments today as well. And the case will be submitted. Thank you all.
Thank you, Your Honor.
This honorable court is now adjourned.